3 of 2022.
My leadership, I'm playing that.
I will not grant you time.
My leadership, I'm just playing this matter we taken in the second half of my leadership. Reason being my leadership, my senior has to come today, but he has went for home and he couldn't come today. In the first half, I will prepare myself and I will argue this case. Just give me.
Now at 2:15, we have one more case to set.
My leadership.
You go records there.
My leadership.
You have your records?
Under heading for hearing under order 41 rule 11 of CPC item 7, second appeal 360 of 2018.
Which is the appellant? SA 360 of 2018. Nobody appears on behalf of the appellant. There has been repeated adjournments at the instance of the appellants. Order dated 19/1/23, 19/9/24, 3/12/24, and 6/2/25. Are quoted as under. However, one more chance is granted to the appellant to argue the case, failing which this case will be dismissed for non-prosecution. Owes this case to you.
Item 8, second appeal 59 of 2022.
I'm playing for a short pass.
There is nobody to argue the case, you start arguing the case.
For 2-3 cases, just to
Who is going to argue?
I'm in this case, Your Worship, but the file is not with me. It's coming.
Let your 11 o'clock. 11.
Item 9, second appeal 63 of 2022.
ये जो ऑर्डर लिखा है ना कश का तो टाइप करना है और उनसे लंच में टाइम चलाना है उसको अपलोड करना है। यस appellant.
It is plenty of second appeal. Suit for a specific formation of contract. It was an agreement dated 26/9/98. Title suit number 93 of 2003, instituted on 5/7/2003. Consideration amount was 1,25,000. Out of which rupees 40,000 was paid in advance at the time of execution of the agreement. And rupees 85,000 was to be paid at the time of execution of the sale deed. Defendant number one was in urgent need of money. Hence, part amounts were paid on different dates. Rupees 10,000 on 12/10/98. Rupees 9,000 on 27/1/1999. Rupees 6,000 on 21/8/1999. Rupees 20,000 on 16/3/2000. Rupees 23,000 on 14/8/2000. And rupees 15,000 on 11/6/2001. Thus, total amount paid was rupees 1,23,000 till 2001. Only rupees 2,000 was left to be paid. On 5/3/2003, when the defendant number one was not ready for execution of the sale deed, a notice was sent that the plaintiff is ready and willing to pay part of the amount of rupees 2,000 and offered him to get the sale deed executed. But in the meantime, in 2003, defendant number one executed a sale deed number 9072 of 2003 on 13/6/2003 in favor of defendant number 2. Both were noticed after filing of the suit. Defendant number one was defendant number executed of the agreement was debarred.
Defendant number one executed that sale deed.
Pardon?
Defendant number one executed.
One executed sale deed in favor of defendant number 2. Defendant number 1 was debarred from filing written statement. Only defendant number 2 contested the claim. The trial court held that defendant number 2 had no knowledge of the agreement when he purchased the property. But the appellate court, on the basis of readiness and willingness of the plaintiff, dismissed the appeal filed by the plaintiff.
Readiness and willingness was decided in favor of the plaintiff by
No,
the
no,
trial
no.
court also.
It was not decided in favor of the plaintiff, against the plaintiff.
It was
Trial
decided
court
against the
dismissed the
plaintiff.
suit on the ground that the defendant number 2 had no knowledge prior
How
to
does that
purchase.
make a difference?
Pardon?
How does that make a difference? Makes a difference?
Sorry.
In a case of specific performance of contract, if the purchaser in between has no knowledge about an agreement of
Yes.
sale, does that make a difference?
Yes. There is provision in a specific performance of contract that if he had no knowledge, he is a bona fide purchaser.
Okay.
Then the plaintiff suit must wait. Therefore, trial court held that defendant number 2 is not aware of the agreement in between plaintiff and defendant number one.
So two findings are important. One is about the knowledge, other is readiness and willingness.
But the appellate court, Lord,
No,
when
first let us be on the trial court judgment. Trial court judgment held that defendant number 2 had no knowledge. Plus, so far as readiness and willingness is concerned, it was decided or
it
not
was-
decided.
It was decided by the appellate court, not by the
Trial
trial.
court did not decide this issue.
No. Lord, kindly have a look to running page 49, trial court judgment. Issues were framed altogether 11 issues.
49. Okay, let us come one by one, right? Maintainable, it's a formal issue. Cause of action and barred by limitation. These two. Suit was held to be within limitation.
Yes, because there was no refusal on behalf of, on the part of the defendant number one. When the notice was given in the year 2003 by the plaintiff to come forward and excuse
As per the agreement, there must be some time frame.
No, not there. Separate.
No
I have
time
got-
frame was there.
Not time.
No.
Thank you.
You have a copy of the agreement?
Yes.
Let me just have.
Peculiar thing is that I was put in possession by this agreement.
So your suit was only for confirmation of possession or recovery of possession?
For recovery of possession.
If you were already put in possession, there was no occasion for recovery of possession.
But the issues were framed, issue number 10,
That's right.
now let three important issues have been dealt with in running page 51. Issue number 8, 10 and 11. After considering the entire evidence on record, the ultimate finding is at page 70. May I take help of my friend
Yes,
for
yes.
reading
Sure.
this?
Internal page 17 of the judgment.
70.
7
7.
running page.
Running.
Internal page 29.
Yes. Can you read it?
Perused the case record, heard the argument as well as after going through the exhibits filed by the plaintiff, defendant number 2 and the evidence laid by the parties on these issues, it is evident that in fact defendant number 1 against whom the case is brought, his conduct is not appreciable, rather he is not contesting the suit, and so many facts which was exclusively within his knowledge has not been disclosed and come out on the record. Rather, it was stated and tried to be proved by defendant number 2. But from the exhibits, it is quite clear that there was an agreement between plaintiff and defendant number 1. And from perusal of exhibit 1, it is well proved that defendant number 1 has signed the agreement. However, in the agreement as page number 3, amount received of rupees 40,000 in figure and word is written by the hand, and in the same page balance amount of rupees 85,000 is also filled up by hand. However, the document is typed, and after going through the exhibits 1, It is evident that the advocate who drafted the same has not mentioned this fact that the content of the affidavit was read over and explained to the parties in Hindi, and as stated above, plaintiff witness has deposed this fact that at the time of payment of rupees 40,000, it was requested rather close to defendant number 1 to bring her mother to signing the document, then payment was made, and rest amount of rupees 83,000 was paid partly by plaintiff to the defendant, which shows that it is also not as per condition imposed in the contract, as it was the second condition that the time of execution of original sale deed in favor of vendee after fulfillment of aforesaid pursuits, the payment shall be paid, but in a span of about 1.5 years, the amount was paid. It is also evident from Exhibit D that the registered sale deed was executed by defendant number 1 in favor of defendant number 2 on 13/6/2003, whereas the suit was filed on 5/7/2003. But till that time, defendant number 2 was not included as a party. Rather, plaintiff has filed an application for including defendant number 2 as a party to the suit on 3/12/2004. This is also shows that plaintiff was not so much interested in the property. After going through the exhibit 1, it is quite clear that page number 2, the condition was imposed that there are several pursuits set as to measure the land, so construct pillars showing location of the actual city land, and after measurement to obtain ground receipt thereafter, and also to obtain approval of LRDC. But from deposition of the witnesses,
Just a minute, brother. I may be allowed to pause for a moment. These all things are to be done. Maximum work has to be done by the defendant number 1 alone, not by the plaintiff. Rent receipt, it has to be obtained by defendant.
Construction of pillars and location.
Construction of pillar was by Amin, who will demarcate the land.
Automatically he will not come.
Not
No.
जब तक
किसी
demarcate
को तो अपॉइंटमेंट करना पड़ेगा ना.
अपॉइंटमेंट होगा प्लेंटिफ का.
The agreement of sale was for an unspecified
It
area
is
of land.
plaintiff's land. Plaintiff will file application before CO for demarcation of the land, and thereafter, after demarcation, pillars will be put to demarcate this is the land.
So far as the agreement is concerned, it did not specify the boundaries of the land.
Yes.
That
Yes,
is correct.
Yes, sir. Therefore, these conditions have been put in the agreement itself. Rent receipt to be obtained by plaintiff. Permission to be obtained by plaintiff.
and the evidence produced by the plaintiff, there is nothing
Just a moment. Even the measurement of the land was not done.
Yes, sir. Because in the agreement itself, it has been, these conditions have been put. Now let
Continue.
proceeding further.
evidence produced by the plaintiff, there is nothing on the case record to show that actual how much land was found on the spot, and accordingly what price was finally fixed. As it was also conditioned that if in the case of lesser area comes out of the verification and measurement, the proportionate amount shall be deducted from the present tentative amount of the consideration.
Let these findings is neither in the agreement nor in the mouth, nor by the mouth of defendant number 1.
But it must be there in the agreement that if
No,
the area
no.
is found less.
Probably, so far I remember, it has to be demarcated, not lesser area or bigger area. in any condition, Millet, I have already paid 1,23,000.
It is there. And that in case the lesser area comes out
Sorry.
of the physical verification
Oh,
and the
sorry,
measurement,
I
the
might have
proportionate
noted.
amount shall be deducted from the present
Yes.
tentative value.
Now coming to the Millet payment, 1,23,000, 1,25,000 में से 1,23,000 हम दे चुके हैं. And the trial court as well as the appellate court has Millet by the impugned order at the operative part from discussion made above.
From the discussion made above, it is well proved that dependent number
नहीं ये
हाँ उसको पढ़ देंगे हम कह रहे हैं कि this finding is there.
No, we will see that.
Yes.
We will see that.
Yes.
इसको पढ़िए ना, इसको पढ़ लीजिए continue.
ठीक है.
The main condition.
The main condition which was imposed by the plaintiff in the contract at page 5 was this, that in the case the bandage loses the same, he shall repay the entire consideration money with interest at the bank rate, beside the cost or cost incurred by the bandage till that point of time. Legal notice which was sent by the plaintiff to defendant number 1 and to his sister, which is Exhibit C, clearly shows that notice to execute sentence was sent to defendant number 1 and to his sister, whereas sister is not party to the suit. On the point of possession and from the conduct of plaintiff as well as from the deposition, it is evident that in fact the possession was never delivered to plaintiff and she was never in possession of the suit land, as no evidence has laid in this regard that how she enjoyed the right of the suit and what benefit or any other works was done by her on the suit land. Rather, defendant number 2 constructed boundary wall and other improvement on the land which was only opposed by the plaintiff by filing case before SDM. As far as purchase of the suit land by defendant number 2, it is well proved that defendant number 1 has executed sale deed to defendant number 2 by registered sale deed which is Exhibit B. And from the deposition of the defendant witness as well as conduct of the plaintiff and defendant number 2 as stated in the deposition, it is quite clear that the fact defendant number 2 had no prior knowledge of any such agreement and defendant number 2 is bona fide purchaser without having any prior notice knowledge of the contract. From the discussion made above, it is well proved that defendant number 1 has received the amount of ₹1,23,000 from plaintiff and there is a condition regarding the return of money with the interest in the contract and conduct of defendant number 1 is not good as he did not contested the suit. So the plaintiff is not entitled to decree for a specific performance, but he is entitled to get decree for recovery of amount advanced with interest. So this issue is accordingly decided, which issue number 11 regarding relief for which the plaintiff is entitled to. That is, plaintiff is entitled to get decree of recovery of amount of ₹1,23,000 which has been given to defendant number 1 in advance with interest. Issue number such and such is settled accordingly.
Now let finding of the appellate court rectify the appeal.
इसका क्या मतलब है? In case the vendee or vendor loses the same case, कोई केस के बारे में सकते हैं cases, he shall repay the entire consideration amount with interest at the bank rate.
Yeah, this is the provision in a specific relief act. Now let the plaintiff preferred appeal. Now appellate court framed or formulated 2 points, 3 points. In para 11, running page 26, internal page 13 of the appellate court.
Running page?
26,
Running page 26.
26,
Yes.
para 11. 3 points have been formulated. Now let In para 19, all the points have been taken together after submission of the lawyers for the party. Running page 33, para 19.
Yes.
All the points have been taken together and the ultimate finding is at page 37, para 22. The facts are there in para 22 just now.
Yes.
We have read the facts. Now the finding is at page 38 from above referred discussion.
Yes.
From above referred discussion, it has been established by the defendant number 2. First, the defendant number 2 is not individual, rather she has purchased the suit land being president of Hazaribagh Cameral Society Hazaribagh. As such, purchaser is Hazaribagh Cameral Society Hazaribagh. The consideration amount of rupees 5,30,000 such and such has been paid by defendant number 2 to the defendant number 1. Therefore, 3 checks as stated in page number 10 of the registered sale dated 13/6/2003. It has also been established that none of the person on behalf of defendant number 2 has got any knowledge and notice of the prior agreement for sale dated such and such. It is also not established that defendant number 2 has already erected boundary walls over the suit land on expenses of amount of rupees such and such. The name of defendant number 2 has been mutated in the Sirista of the state of Jharkhand. The suit land is in possession of defendant number 1 since the date of purchase.
2. Oh, mistake. Purchase date said defendant number 2 is in possession.
As such, in the above context of evaluating the provision of section 16C, section 19B and section 20 of a specific relief date, as well as conduct of the party elapsed of the time about 24 years from the date of agreement of sale dated 26/9/98, and the decision as aforesaid cited on behalf of the party, it is obvious that the defendant number 2 is entitled to get the protection of section 19B of the specific relief act. In such circumstances, decree for a specific performance of contract for sale with regard to the suit land cannot be granted to the plaintiff, but so far with regard to the amount of rupees 1,23,000 paid by plaintiff to the defendant number 1 is concerned, the learned trial court has ordered for recovery of rupees such and such with simple interest at rupees 15% per annum, which has to be paid by the defendant number 1 to plaintiff from the date of filing of the suit till payment of total amount with interest, which seems to be just and proper. As such, point number A, B and C are inserted accordingly.
So prior knowledge, there is concurrent finding that there is
Yes,
no knowledge.
concurrent.
And if there is a concurrent finding that he had no knowledge
No.
after appreciation,
Yes, 19(1)B.
then under such circumstances, what question of law can be formulated in this case?
So far, question of law formulated by me is
It will be of no use, because if that particular finding is coming in your way, your readiness and willingness, your whatever are the basic ingredients for specific performance act, but if that finding is coming in your way, unless you come across, you meet that finding and say that it is perverse, there is no question of any formulation of point of law.
right.
ठीक है ना, कुछ नहीं बन पाएगा. There is a
Right.
concurrent finding recorded by court.
Right. वैसे हम फॉर्मुलेट किए थे मेमो में, वो था तो B and C.
B. Whether while affirming the judgment and degree of trial court, the learned appellate court erred seriously by declaring the sale deed of defendant as illegal and valid in spite of setup into a clause that before getting registered selling, purchaser had to make an inquiry regarding current status of land in question. C. Whether both the court below have illegally taken recourse of section 19B of the specific relief act in view of the fact that the plaintiff was always ready and willing to perform his part of agreement and in pursuance thereof mutated her name improved the land by putting pillars, etc. And as such, she is entitled for decree of a specific performance of agreement by executing.
पुटिंग पिलर्स का कहीं एविडेंस नहीं है
ठीक, कोई बात
एज द लॉर्ड
देखिए सेकेंड अपील नंबर 63 of 2020 और सीनियर एडवोकेट का नाम लेंगे मिस्टर मनोज प्रशांत along with मिस्टर
पवन
Pavan Prashant. The learned counsel appearing on behalf of the appellants. The suit arises out of the plaintiff is the appellant before this court and has challenged the judgment and decree passed in civil appeal within bracket title appeal bracket close number 15 of 2015. Whereby the judgment and decree passed in title suit number 93 of 2003 has been upheld. ऊपर जो है ना किस ऑर्डर से अराइज हो रहा है वो डिटेल the learned counsel for the appellant has submitted that though there are concurrent findings involved in this case, but still the appeal is fit to be admitted on account of substantial question number B and C as formulated in the memo. The learned counsel submits that the suit was filed for specific performance of contract and the agreement was dated 26/9/1998 and title suit was instituted on 5/3/2003 numbered as title suit number 93 of 2003. As per the agreement, the total consideration amount was 1,25,000 and 40,000 was paid in advance and remaining 85,000 was to be paid at the time of execution of the deed. It was a specific case of the plaintiff that the defendant number 1, who was party to the agreement and owner of the property, was in urgent need of money and an amount of rupees 10,000, 9,000, 6,000, 20,000, 23,000 and 15,000 was paid on 12/10/98, 27/1/99, 21/8/99, 16/3/2000, 14/8/2000, 11/6/2001, total being rupees and if 40,000 amount is taken together, the total amount of rupees 1,23,000 was already paid and what was remaining to be paid was only rupees 2,000 for the purposes of execution of the agreement. The plaintiff issued a notice dated 5/3/2003 to defendant number 1 for the purposes of execution of the deed and expressed his readiness to pay rupees 2,000, to which the defendant number 1 did not respond. And in the meantime, the defendant number 1 executed a sale deed number 9072 of 2003 dated 13/6/2003 in favor of defendant number 2. and consequently, since the deed was executed in favor of defendant number 2, they were also made party in the suit. Defendant number 1 was debarred from filing the written statement, and the suit was contested only by defendant number 2. The learned counsel has submitted that the learned trial court has not properly considered the provision of section 19 within bracket B of the Specific Relief Act, and it was for the subsequent, it was for defendant number 2 that before getting the registered sale deed, he was required to make necessary enquiries in connection with the status of the land in question. The learned counsel has also submitted that it was a specific case of the plaintiff that after payment of the consideration amount, they were also put in possession of the property, and such was a stipulation mentioned in the agreement of sale itself. After hearing the learned counsel appearing on behalf of the parties, on behalf of the appellant, this court finds that the aforesaid fact which has been stated by the appellant with regard to execution of an agreement of sale and payment of consideration amount of rupees 1,23,000 is not in dispute, and the learned trial court had directed the defendant number 1 to refund the amount of rupees 1,23,000 with interest. The learned trial court, and it is all further not in dispute that it is further apparent that the defendant, it was only defendant number 2 who had contested the suit before the court. The learned trial court had formulated as many as 11 points for consideration, and the learned trial court decided, which are as follows. The learned trial court decided issue number 8, 10 and 11, white paragraph 6 of the judgment. And recorded a finding that defendant number 2 was in possession of the property after constructing boundary wall, and has also recorded a finding that the defendant number 2 was a bona fide purchaser having no prior knowledge of agreement of sale. The learned trial court also referred to the agreement of sale and its clauses, which required measurement of land, construction of pillars, exact location of the scheduled property to the agreement, and certain acts which was, and certain other acts which was required to be undertaken prior to execution of the sale. The learned trial court ultimately, primarily on the basis of possession of defendant number 2 and also the admitted fact that the sale deed was executed in favor of defendant number 2, and that the defendant number 2 was a bona fide purchaser and had no prior knowledge of the agreement, dismissed the suit. The learned appellate court also considered the materials on record and came to a specific finding that has also considered the materials on record and formulated the following points as point for determination. In paragraph number 11 of the appellate court judgment, which is quoted as under, the learned trial court took all the points for determination together, while paragraph 19 discussed the materials on record and ultimately recorded a finding that the recorded a finding that the defendant number 2 had already executed the boundary wall over the land and incurred expenses, and that it was established that the defendant number 2 did not have any knowledge. It was also established that none of the person on behalf of defendant number 2 had any knowledge and notice of the prior agreement of sale dated 26/9/1998, and ultimately recorded the finding that and ultimately dismissed the appeal by referring to section 16C and 19B and 20 of Specific Relief Act 1963, as well as the conduct of the parties, and that 24 years had elapsed from the date of the agreement of sale dated 26/9/1998. The learned appellate court held that defendant number 2 was entitled to get the protection of section 19 within Article 3 of Specific Relief Act, and upheld the direction, dismissed the appeal and upheld the direction of the learned trial court to refund an amount of rupees 1,23,000 to the plaintiff by the defendant number 1. This court finds that both the courts have scrutinized the materials on record and have come to concurrent findings with regard to possession of the defendant number 2, and also the fact that defendant number 2 had no prior knowledge with regard to the agreement of sale. This court finds that the points of law as formulated by the in the memo of appeal and pointed out by the learned senior counsel for the appellant are essentially points regarding appreciation of the materials on record. No perversity as such has been pointed out by the learned counsel for the appellant with regard to appreciation of materials on record, and there being concurrent findings with regard to the benefit which is to be given to the defendant number 2 under section 19B of Specific Relief Act. This court finds no substantial question of law involved in this case, which is hereby dismissed. Yeah, thank you. आप लोग इतना साध के अच्छे से बहस करते हैं ना कि ऑर्डर लिखाने में दिक्कत
आप इतना कूलली सुनती हैं कि हम लोग को बहस करने में अच्छा लगता है।
तो कूल नहीं रहेंगे तो कैसे ही होगा। सेकंड अपील तो एक तरह से लास्ट रिसोर्ट है ना।
इसके बाद सुप्रीम कोर्ट कौन जाता है?
नहीं जाता है चाहे नहीं जाता है, स्कोप बहुत कम है और कॉन्करेंट फाइंडिंग 3 कॉन्करेंट फाइंडिंग के बाद बहुत मुश्किल है।
ऑनलाइन
ये जरा ले लीजिए। ये एक और पेज है।
Passover case item 8, second appeal 59 of 2022.
Litigation, I'm playing the matter he kindly kept on next video.
अभी तो पास हुआ है।
There are certain points of research litigation in this case, so I'm playing.
ऐसे नहीं होता है।
Next,
लास्ट चांस कई बार हो चुका है, फाइन भी हो चुका है।
for removal of defective litigation.
not for removal of. No? रिमूव द डिफेक्ट तो ऑलरेडी हो गया 29/8/2024 को. आपको 17/10/2024 को बाय वे ऑफ लास्ट चांस एडजर्नमेंट हुआ था. उसके बाद 25/11/2024 को 1000 रुपये फाइन कर दिया.
As a last chance,
नहीं ऐसे नहीं.
next
आप पढ़िए, शाम सेकेंड हाफ में आएंगे. हम इसको एडजर्न नहीं करेंगे. एडजर्न हम नहीं करेंगे. करेंगे तो 10,000 रुपये कॉस्ट के साथ करेंगे. इससे कम एक पैसा आइए. 3 केस रख दिए सेकेंड हाफ में. अब कोई भी केस सेकेंड हाफ में नहीं जाए. अब जो भी एडजर्नमेंट होगा कॉस्ट के साथ होगा एडजर्नमेंट.
Item 10, second appeal 84 of 2022.
This is the defendant's second appeal. It is against the judgment of reversal. The plaintiff,
Suit was dismissed.
the suit was decreed. The
Okay.
plaintiff's suit was decreed.
Suit was decreed.
The plaintiff's suit was decreed.
Appeal was allowed.
Appeal was allowed. The plaintiff sought for a relief for their share by way of filing the partition suit.
It was a partition suit.
Yes.
Kindly give me the suit number.
Yes. That is titled partition suit number 60 of 2014.
Partition.
I stood corrected. The suit was dismissed on contest.
Suit
Was
was
dismissed on contest.
dismissed
On contest.
on contest.
The suit was
Appeal was allowed.
appeal was allowed.
Okay. So appeal was allowed, and therefore the defendant
Yes.
is the appellant.
Yes.
Okay. Title partition suit number.
This is 60 of 2014. 60 of 2014.
2001.
1.
All the parties, genealogy, etc. is admitted? Or
Yes,
disputed?
yes. There is no dispute with regard to that.
No dispute.
Genealogy and then date of death.
Regard to genealogy, date of death,
Because it has.
etc. is not in dispute.
No.
Correct?
Yes.
Is there any party who is other than the family member?
No.
No third party.
No third party. Because it is not a case of PSN of any third party right.
Is there any story of previous partition?
Previous partition, it is not a case of previous partition.
Then why the partition suit was dismissed?
Yes, the partition suit was dismissed, basically holding that there is no unity of title. That was the gist of the findings. And since it was found that the plaintiffs, who are the heirs, female heirs, who were married during the lifetime of their father, they did not inherit the property as the legal heir at that point of time.
During lifetime. When did the father die?
The father died in the year 1972. Before that, I will just give a brief genealogy, particulars of the genealogy. It is not much. There was one Barkhanath Panjiara, who was the recorded tenant, the common ancestor. One Barkhanath Panjiara.
Yes.
He died leaving behind two sons. Karnadhar Panjiara.
Just a minute. It is there, the genealogy is there, you can refer to the genealogy.
Yes. that
Page
is-
number 24. or the partition suit?
Yes.
You tell us what do you want to point out.
And I will show from there on. The Barkhanath Panjara and Karnadhar Panjara and Prahlad Panjara, and it is the case that Karnadhar Panjara and Prahlad Panjara, it is admitted case, separated after death of Barkhanath. There is no dispute with regard to that.
When did they separate?
There is the date of, is it not there, soon after their death. The pleading is that after their death, and
Is
that
there any finding?
on that there is, since there was no issues on that, no dispute on that, so there is no finding on that. Then we are
The
concerned.
plaintiffs are the descendants of Karnadhar Panjara.
Yes, both parties are descendants of Karnataka because Prahlad.
That's right.
Yeah.
Prahlad is now out
Yes,
because his
yes.
share is already
Yes,
separated.
yes, yes. Now Karnataka has 5 sons. The plaintiffs are plaintiffs and the defendants. They both are from Devendra. Devendra. Now the other sons of the Karnataka are also not concerned. Now Devendra, he was his widow was Kamini Panjara. Devendra died in the year 1975.
1975. Died.
And it is important to note that his son Amulya, through whom the plaintiffs are claiming, he predeceased Devendra. Amulya died in the year 1972.
1975.
These are not disputed. Devendra 75, Amulya 70. So Devendra died, leaving behind his daughter-in-law, that is the mother of the plaintiffs, Ivarani, so, wife of Amulya, and apart from that, Devendra's widow was there, Kamini, and this defendant, Sarat, was there. And
Sarat is defendant number?
Sarat is the sole defendant.
Sole defendant number.
Yes.
Sole defendant.
Sole defendant. And Devendra left behind another son.
What about Braj Dullah?
Yes, another son, Braj Durlabh Panjara.
Huh.
He was also there. But it is the case that he died in 1998 in state of unmarried state. 1998. That is also undisputed. Both, that is the 1998 in unmarried state. Now thereafter, this Kamini was there, the widow of Devendra. Ivarani was there, the mother of the plaintiffs, and then this appellant, the original defendant, remained.
Sarat Panjara.
Yes, Sarat Panjara. This appellant. They remained.
This Kamini and Ivarani,
Yes.
were they co-plaintiffs?
No, Kamini, because they were dead by that time.
What is it?
Kamini died in the year 1998,
1998.
and Ivarani died in 1997. These dates are also undisputed. The date of deaths are undisputed.
When was the suit filed?
This suit was filed in the year 2014.
2014.
14.
By
So-
that time, when it was filed in 2014, so the legal heirs who survived were Sarat Panjara, the sole defendant,
Yes.
and Purnima, Nilima, and Gautam.
Yes.
Gautam is son.
No, actually, she is also daughter. Gautam, alias Mini Mandal.
These are 3 daughters.
3 daughters.
Yes.
Now, it was our specific case. The plaintiff's case was that they were in state of jointness, the plaintiffs, along with Sarat. It was their case. It was also their case that all of them 3 were married, and the date of marriages have also come, which they have admitted in their evidence also.
What is the
The-
date of marriage?
The marriages are prior to 1998. All the 3 marriages are prior to 98. I will just refer from their deposition only where they have stated the date.
All 3 married. How the entire property will devolve upon the sole defendant? Under what provision?
Yes. Now at that point of time,
They are governed by Mitachara law.
Mitachara law. At that, so far as the amendment, section 6, which has been incorporated in the year 2005, that according to us is an error committed by the learned appellate court while considering that amendment and while considering the judgment rendered by the Honorable Apex Court in the case of Vinita. Because this amendment, it is retroactive, so it will apply in a case where there is no previous partition or where there is no previous family arrangement, it will certainly apply. But here is a case where these plaintiffs, they were not the legal heirs by virtue of their status at that point of time under the prevailing law. Because when their mother died, she died in the state of jointness along with this appellant. Eva Rani, the mother of the plaintiffs, died in the state of jointness along with this appellant, the defendant. And so, after her death, this defendant became the sole legal heir, sole surviving legal heir, and he came in exclusive possession. Because the moment they were married during the lifetime of their mother or prior to death of their mother. So they did not become, at that point of time, they were not the co-parsoner, which has now, that right has now been given by this amendment, that the females also become co-parsoner by virtue of their status, by virtue of birth, like male legal heirs. So, but at that point of time, it was not the law, and further, since they were married and since their status changed during the lifetime of their mother, so her mother, in state of jointness along with this appellant, died. And then when her mother died, the entire property devolved to this appellant defendant solely, and he came in exclusive possession.
How do you say exclusive position?
Exclusive possession because there was no other legal heir at that point
Any
of time.
mutation exclusively in his name?
Mutation, that document has not come. Mutation has not come.
So merely because there is only one surviving male here,
Yes.
the right, you will assume that that there is no need for any partition.
There the issue
And
is
the jointness goes.
yeah, that is the distinction, because had it been and in the present days,
Exclusive possession does not mean that whosoever is in physical possession of the property.
since there was no unity of title and possession thereafter, because for maintaining
Therefore, some more act was required, apart from merely saying that he was the sole surviving legal. Some more act was required. You did not get the entire property mutated in your favor.
There is one thing.
There was nothing of that sort.
No, those things are not. Whatever is there on record, that only we can place on. Now there is one thing which perhaps the learned first appellate court has not considered, that the status of the plaintiffs as on the date of death of their mother, they did not become the legal heir by virtue of their status at that point of time.
They were the legal heir. They might not. Whether they were the co-partner is something which.
Yeah, because
They were the legal heir.
because
Females are the legal heirs.
legal heirs, but for the purpose of the Hindu Succession Act, as per the definition of heirs who has a right to succeed, so they did not have a right to succeed by virtue of their status at that point of time, as their mother, who died in the year 1997 while in a state of jointness along with this appellant, and since thereafter this appellant was only there, and they did not have any right at that point of time. They did not have any right. Things would have been otherwise if it would have been after
Succession agreement.
2006. Had it been after 2006, then we could not have said this. But at that point of time, no right
Which
accrued to
judgment are
them.
you relying upon? I think this issue has been settled by the Supreme Court.
Yes, that has been settled in a background where there is a previous arrangement, or where in not such a circumstances where the females
Where there is sole surviving here, that does not mean that the jointness goes.
that is the one thing which is required to be decided, and that will be a proposed substantial question of law from our side in the given facts. If I'm allowed to place the definition of
You show me that judgment. And first, let us see the findings.
yes,
Findings of the trial court.
yes. findings of the trial court that starts from page 37. The basic issues, issue 6 and 7. Because the trial court came to a specific finding that since there is no unity of title and possession, so there is no occasion for running page 37, internal page 30. From the
Issue
last
number 4 and 5, correct?
issue number 6 and 7.
6 and 7.
7.
Okay.
The plaintiff states in
Just a
para.
moment.
Yes.
Yes, please. The plaintiff states.
Yes, the plaintiff states in para 4 of the plaintiff that common ancestors, Barkanath Panjara died long ago before gangster settlement operation, leaving his two sons, recorded tenant Karnadhar Panjara and Prahlad Panjara, who after death of their father Barkanath Panjara separated in base and property.
These are all technologies.
Yes, yes, yes. Then we may come from just after the middle 1, 2, 3, 4, 5, 6, 7.
It may be mentioned
Yes,
here.
yes, exactly. I was referring to. It may be mentioned here that Jamabandi number 11 of Mauja Kenpani recorded Isbal. Jamabandi number 11. And is not included in the said property as there are
Suit property.
yes, as there are numerous co-sharers not joined in the suit, as the same may be caused unnecessary disposal of the suit. Devendra Panjara had 3 sons, namely Amulya Panjara, Braj Durlab Panjara and Sarat Panjara. Out of whom Amulya Panjara predeceased his father in the year 1972, leaving behind his widow Ivarani Panjara and 3 daughters, Purnima, Nilima and Gautam, as his legal heirs and successors. Devendra Panjara died in the year 1975, leaving behind him his widow Kamini Panjara, his 2 sons Braj Durlab Panjara, Sarat Panjara, and his daughter-in-law Ivarani Panjara, and also 3 granddaughters as his legal heirs and successors, who jointly inherited the Situlia property and jointly came into possession. It may be mentioned here that Braj Durlab Panjara predeceased his mother Kamini Panjara in unmarried state in the year 1998. Thereafter, Kamini Panjara also died in the year 1998, leaving behind him her daughter-in-law. This is something which is not proper in their plaint itself. It appears they have missed the sequence. Thereafter, Kamini Panjara also died in the year 1998, leaving behind him her daughter-in-law Ivarani Panjara and 3
No, Kamini Panjara.
died in 1997. They themselves say. They themselves say in their plaint that
No, Kamini Panjara, as you said, she died in
Kamini Panjara in 1998 and Ivarani died
you say 1997.
Ivarani died 1997 and Kamini died 1998. Kamini 98 and here this pleading.
But this is something else.
Yes, because
Thereafter, Kamini Panjara also died in
that is
1998,
that
leaving behind him daughter-in-law Ivarani Panjara
Panjara.
and
That
3
appears-
granddaughters.
yes, that appears to be error some.
No, ऐसा error.
नहीं एक बार इनका प्लेट देख लीजिए ना ये
Plaint का बात नहीं.
नहीं एक बार ये देखिए देखने से ही पता चल जाएगा 11 और 12 में एक बार देख लीजिए वो लगता है हम लोग को लिखने में वो लोग खुद ही बोल रहे हैं कि इबारानी के 97 हुआ इन वो 2 पैरास खाली देख लीजिए प्लेट
1997 में
हाँ उसको लिखने में वो लोग
कामिनी पंजारा के बारे में लिखे हैं कि she died in 1998 leaving behind a daughter-in-law. जो लिखा है वही लिखा है.
और उसके बाद नीचे लिखते हैं कि इबारानी के 90
conflicting है ना.
हाँ
Conflicting है. You cannot say that they are clearly stated. जो आपके प्लेन में लिखा है वही यहाँ.
हाँ वो उन लोग का they were the
लिखने में कोई
plaintiff.
गलती
हाँ
नहीं.
they were the plaintiff and
आगे नहीं.
then thereafter Kamini Panjara also died in there, leaving behind him her daughter-in-law Ivarani Panjara. So this becomes false as per their own assertion, and 3 granddaughters and also a son of Sarat Panjara as her legal heirs and successors, who jointly inherited the suit property. Ivarani Panjara and Sarat Panjara separated in. Now this is important. Separated in mess and property Similarly operated separate cultivation and supervision of the suit lands without final partition by meets and bounds. When the reply of the defendant to this paragraph is seen, the defendant states in reply to our written statement, in reply to para 4, 5, 6, the contents of 4, 5 are admitted. The content of para 6 is fact that 5 sons grandmother were separate in this is admitted. Adjournment as regard new settlement is matter of document and plaintiffs. The contents of para 7 of the plaintiff is admitted with submissions that plaintiffs are not heirs. The contents of para 9 of plaintiff is admitted. Para 10 of plaintiff except the fact that plaintiffs jointly inherited the suit property. Other facts are admittedly the plaintiffs never inherited nor in possession of suit property or any part thereof. Para 11 of the plaintiff is partly correct and partly incorrect. It is submitted that after death of family, the suit property inherited and held by the defendant exclusively. Para 12 of the plaintiff strongly denied. 13 of the plaintiff is wrong and submitted that plaintiffs never inherited the suit property at any point of time and only defendant inherited and held exclusively. Para 14 of the plaintiff is blatantly false and they are denied. Para 15 is false, denied, 16. Now the evidence of the plaintiff is required to be scrutinized on this point of time. In para 5, partition among 5 sons has been admitted. When the cross-examination of the defendant is seen in para 28, she says she cannot tell the disputed land's Javabandi number. In Javabandi Parcha, she knows the name of Devendra only. In para 38, she says it ought to be plaintiff, as appears from the deposition which I have tallied. She says in para 38 of cross, she says that the plaintiff has been written by her husband. In para 44, the witnesses says that she stayed in her matrimonial home only for 6 months, 7 months, and rest of the months she stayed in the suit property. In para 45, they say very unnatural thing that she has voter I card and ration card at 2 places, at matrimonial home and the suit property also. In para 46 of the cross, his remaining sisters have also voter I card and ration card at 2 places. In para 57, she says all the 3 sisters are jointly cultivating. There is a house in Tumka which is 2-story and the land is Basaudi, which was purchased in the 97. It was purchased in the name of his mother and subsequently it was mutated. She cannot tell the consideration of the land price was joined with other brothers in the family and he was the karta of the joint family. PW2 did not support the prosecution case. In para 17, he does not know what is written in the affidavit. He has no knowledge about the suit property. He does not know in whose name the purchase is there. In para 35 cross, he says that the land of Devendra and his brothers were separate. In para 39 of the cross examination, the witness after the
You are just reading it. We do not know for what are you reading it.
now
What do you want to derive out of it?
Now these findings, on this basis, the next page, the conclusion, on basis of this, page 41. The plaintiff has failed to prove that there was unity of title and possession between both the parties regarding the disputed land in any manner. Hence, issue number 6 is decided against the plaintiff.
Let us read. The plaintiff has filed gangster settlement
Parcha
and not the final
Parcha.
Aage
The
बढ़िए.
gangster Parcha was not exhibited by the plaintiff. It was not exhibited, and even otherwise, the gangster settlement Parcha is in Bengali for which no translation was provided by the plaintiff, and as per his government, the gangster settlement Parcha is for Javabandi number 5, and where the suit land is seen in the plain it is 5K, for which no Parcha has been filed by the plaintiff during his entire evidence. In fact, no exhibit has been marked, but subsequently they filed a petition annexing this. So this was not taken on. This was not allowed. So on this, I was just referring these findings on issue number 6, that after consideration of the evidences adduced by the plaintiffs, the learned first court came to the conclusion that there is no that they have failed to prove this unity of title and possession between the parties regarding the disputed land, and so this issue was decided against the plaintiff.
And admittedly, the property is an ancestral property. Admittedly, there has been no partition.
Yes. No
This is an admitted fact. No partition.
Yes.
You
yes.
say that if there is only one male here, there is no requirement of any partition. The entire property devolved upon him immediately upon death of all the persons, and the fact that all the daughters were married.
Prior to that death of their mother.
Of them.
prior to death of their mother, prior to 1990. That is their admission also in the deposition.
As regards issue number 7, kindly read this.
Yes. When the plaintiff has failed to prove unity of title, the failure is multifarious and one-sided, the valuation of the suit is also not proper. The plaintiff has himself admitted in para 14 of the plaint that Ibarani Panjara and Sanat Panjara separated in base and property, similarly operated separate cultivation and superstition without final partition by base and property. The period from which such separation was such
Appellate court,
yes, appellate court judgments.
what is the point of determination?
Yes. That is point is at page number 16, running till 16, internal page 6. Mainly one point was formulated, that with regard to unity of rightly formulated, whether there is unity of title possession right between parties regarding schedule of the plaint or not. Then after discussing the pleadings, these 2 pages, the pleadings are there, 6.
Para 12.
Yes. Para 11 he discusses and then para 12. On further perusal of the case record, it transpires that it is admitted that in due course the 5 sons of so and so 5 equal sets, and they all separated one when they mutated, conforming and accepting the said partition. Separate Javamadis were created and recorded registered. Then page 10, office of in which new Javabandi number 5K being part of the sale of the branch of Devendra Panjara. Further, it is submitted that appellants filed the suit for partition of the land subset Javabandi number 5K and the plea that parties are possessing the land as per their convenience without any partition of the land of Javabandi. Further, as per admitted case of the parties for which a separate was created for part of the last Javabandi number 5 of Mauja Kendamani, and this was the admitted case of both the parties. As such, there was no reason to make out a third case to complicate the dispute between the parties by holding the Parcha of Javabandi number 5K. Was being produced by the record will reveal that said Parcha during present settlement has been prepared in name of the parties to the suit. On further perusal, this is about the finding in the trial court, the document which is not there on record. On further perusal of the case record, it appears that Durla Panjara predeceased his mother in unmarried state in 1998, and after death of Kamini in 1998, leaving behind his daughter-in-law Ivarani and granddaughters namely Purnima, Nilima and Vini, and also a son, Sarat Panjara, and successors who jointly inherited the property. And after death of Ivarani, had 3 daughters as the legal heirs and successors who inherited suit property, and like the defendant have been coming in possession of suit property on payment of rent through for the sake of convenience. Further, it is apparent that as per convenience and ignoring the presumption of jointness of parties, the learned court below has come to an erroneous finding, and at the same time without properly understanding the actual dispute between the parties wrongly and illegally decided issue number so and so. And then refers to section 58, that facts admitted need not be proved. And then
Para
30, with reference to this amendment on 995, a major and important amendment. 6, section 6 is quoted: devolution of property interest in co-person in property on and from commencement of the Hindu Succession Act in a joint Hindu family governed by the Mitakshara law. The daughter of a co-person shall by birth become a co-person in her own right in the same manner as the son. So, on and from the commencement of the Hindu Succession Act in a joint Hindu family governed by the Mitakshara law, the daughter of a co-person shall by birth become a co-person. So, this will happen from on and from this date, from coming into force of this amended act, by birth become a co-person in her own right in the same manner as the son, have the same rights in the co-person property as would have been had if she had been a son. So the appellant, on behalf of appellant, the contention is that after 2005, pursuant to this amendment, the status has changed. But at that point of time, when the cause of action was claimed, and on that cause of action, the partition suit was filed, claiming a co-personary right. At that point of time, the plaintiff did not had a co-personary right, which has been created.
Vinita Shah judgment padi?
Yes.
In Vinita Sharma, where is that judgment?
Yes.
आप ऐसे किताब दे देते हैं, लिस्ट नहीं देते हैं. मतलब this is, what is this? You read it for yourself then?
I am giving them.
No, I will not read it. You are supposed to read it. ये कौन सा तरीका है?
इसको क्या बुलाते हैं?
छूट जाता है मतलब कि
मतलब छूट गया, लिस्ट देना भूल गया या प्रिंट लाना भूल गया, मिस हो गया, हम बैठे हुए थे यहाँ पर.
हमेशा मिस हो जाता है. पहली बार
आप-
नहीं है.
नहीं
उसके
हमेशा
बाद
नहीं.
आप बोलेंगे बाद में जजमेंट दे देंगे, आप पढ़ लीजिए.
अब
ये
आज
गलत
हुआ,
बात है ना. This is the only judgment which has been relied upon by the appellate court and you are also placing that judgment. ये जजमेंट मंगाइए 2020 वॉल्यूम 9 एसएससी पेज 1.
इस पे जो इशू ऑफ लॉ प्रपोज्ड है, एक बार खाली उसको देखेंगे. ये बोल रहे हैं कि वो
देखिए
एक्ट
ये
है.
इशू डिसाइड हो चुका है.
हाँ, डिसाइड हो गया.
As per the provisions of law, the substantial question of law is to be framed only under such circumstances where the issue is not, issue is still fluid. This issue has been settled by the Supreme Court.
Now in the given facts, in the
नया जजमेंट भी आया, वो तो आप लेके नहीं आए होंगे.
नहीं,
वो आपको पता नहीं
in
होगा.
the given facts, the issue is that on that date, when they claim a cause of action and they claim to have a co-parcenary right, which is the sine qua non for claiming partition, they did not have that co-parcenary right at that point of time. They being married, and their mother having died in the state of jointness, and so the property vested absolutely to this defendant. That is the only issue which
आप
has not
देखिए
been.
ना यहाँ पे क्या इसका समरी पढ़िए जो इम्प्रिंट ऑर्डर में है, पढ़िए गलत लिखा है.
No, this is the findings.
Has it been wrongly written?
This-
विनीता शर्मा पढ़िए.
This is the finding. This I cannot dispute. This is the finding.
You read it please.
Yes.
वो सबसे इम्पोर्टेंट चीज आप पढ़ ही नहीं रहे. पढ़िए.
These provisions contained in subsection 6.
नहीं इन विनीता शर्मा.
हाँ, वही उसी को पढ़ रहे हैं. ये जो नीचे लिखा हुआ है, answer the references under the findings जो है.
हाँ.
The provisions contained in substituted section 6 of the Hindu Succession Act 1956 confer status of co-parcener on the daughter born before or after amendment in the same manner as the son with same rights and liabilities.
That's एक second please hold on. Right? So it is irrespective of the fact whether the daughter is born before or after the amendment.
yes.
She acquires the status of co-partner by
Co-partner, yes.
virtue of this particular amendment. Next one, Roman.
Since the right in co-parcener is by birth, it is not necessary.
The right can be claimed.
Yes, the rights can be claimed by the daughter born earlier with effect from 9/9/2005 with savings as provided in section 6(1) as to the disposition or alienation, partition or testamentary disposition which had taken place before 20th day of December 2004. Yes.
So in a case where there is no disposition, where there is no alienation, and where there is no partition. Right? So in a circumstances where there has been no partition and there was no occasion for partition as per deed and privilege law, according to you, because he was the sole surviving legal heir, what is the status of the daughter? Right?
No, the fact.
आगे बढ़िए. Since the right is in co-custody is by birth, it is not necessary that the father co-partner should be living as on 9/9.
This
So it
was
is irrespective of his death.
this was decided in the case of Prakash by the
आगे
Honorable
Roman
which has-
Roman the
The statutory
statutory
fiction of partition created by proviso to section 6 of the Hindu
धीरे
Succession.
धीरे पढ़िए.
The statutory fiction of partition created by proviso to section 6 of the Hindu Succession Act as originally enacted did not bring about the actual partition or disruption of co-custody.
पढ़िए आगे.
The fiction was only for the purpose of ascertaining share of deceased co-parcener when he was survived by a female heir of class 1 as specified in the schedule to the Act of 1956 or male relative of such female. Referring to section 8 of the Hindu Succession Act. The provisions of the substituted section 6 are required to be given full effect. Notwithstanding that a preliminary decree has been passed, the daughters are to be given share in co-parcenary equal to that of a son in pending proceedings for final decree or in an appeal.
Roman 5 पढ़िए.
In view of the rigors of the provisions of explanation to section 6(5), a plea of oral partition will be registered under the provisions of Partition Act or effected by a decree of court. However, in exceptional cases where plea of oral partition is supported by public documents and partition is finally evinced in the same manner as it will be effected by a decree of court.
You see, your exclusive possession could be gathered only by some material from your end that after the death you got the entire property as exclusive possession and some mutation, something had happened. That you have not undertaken.
Now it is their case that they were separate. It is their case in the plaintiff.
Who were separated?
The plaintiffs say. The plaintiffs
They were separated from whom?
from the defendant. They say that is recorded by the learned trial court from their pleadings. If
No, 5 brothers were separated.
no, their pleading is there.
No, it is not their
if-
pleading. They are
page-
pleading that they were separated in mess
and property.
and property, but there was no partition
Huh,
by
mess-
meets and bond.
Even,
But there was no partition by meets and bond.
without final partition by meets and bounds.
Yes,
Without
but people
final.
can remain separated in mess. There is no problem about it. People can remain separated in mess. There is no problem about it.
But so far as joint possession, that is a requirement for claiming partition. Joint possession or unity of title. That has not been proved in this case.
आगे पढ़िए पैरा 14 पढ़िए.
Yes. In light of the said amendment passed by the legislature, decision laid down by the Honorable Apex Court and depositions made by the defendant as well as witness and after careful consideration wherever matters not before the learned court below this court finds and holds that the learned court is being clearer in appreciation of the oral as well as documentary evidence brought before this court. This court finds irregularity and illegality in coming to the conclusion by the learned court below because there is no need to prefer which passed by the court. Regarding issue number 6 and 7 is hereby set aside. Accordingly, the court determines that there is unity of title and possession right between both the parties regarding schedule and intent. Hence, point 1 is decided in favor of plaintiffs and against the respondent. This, while recording the
You
findings,
see, they say that Ivarani Paranje and Sarat Paranje separated in mess and property similarly operated separate cultivation and supervision of land without final partition by meets and bounds. This is what they say. That during the lifetime of Ivarani there was some kind of separation. The plaintiffs on inheritance and succession like that of defendants have come in joint possession of the suit property on payment of rent through for sake of convenience, cultivation and supervision of the suit property. Since some time had passed, the defendant has been quarreling with regard to supervision of cultivation and enjoying the suit property, and therefore they demanded a partition by meets and bounds.
so far as the burden was on the plaintiffs to prove this fact,
What fact?
that there was unity of title and possession.
No,
Now-
there is a presumption in law that in a joint
That-
family, there is a presumption in law, but
That-
particularly when that is what the appellate court has said.
That presumption is, first of all, it is a weaker presumption, rebuttable presumption.
It's a very strong presumption.
But it doesn't.
It is very strong
Presumption of
presumption.
jointness does not mean that there is presumption of jointness of the properties. This has also been held time and again. That presumption of jointness doesn't mean that presumption of jointness of the properties also. That is one thing. And here, so far as the purchase is concerned, there is no document which the learned trial court has, learned first court has considered, and the learned appellate court has given a finding without the document being on record. Page 20. This purchase of Jamandi 5K, which was not the final survey settlement, This was never exhibited. This was not on record. There is no such exhibited document, which the learned trial court has discussed. And however, that fact has perhaps not been properly considered by the learned appellate court. If page 20 is seen with regard to that parcha, where the learned first appellate court says that there was no need of making any third case with regard to the Jawabandi, and the learned appellate court says that the said parcha during present settlement has been prepared in name of the parties to the suit. The said parcha was not on record. The learned first court says that the parcha was not on record. It was filed later on, but it was not exhibited. Moreover, it was in Bengali. It was translated version was also not there. But the learned appellate court records a finding that it has been prepared in the name of the parties to the suit. The parcha being not on record. So for that finding is concerned, that can be considered to be a perverse finding which is not based on a material on record or evidence on record.
You are the defendant, right?
Yes.
Read page number 18. Internal page 8.
Yes. Yes. This honorable court is referring to our witnesses.
Para 11.
Yes, sir. Now that is another error. Plaintiff's witnesses. Plaintiff has filed a case. Plaintiff has to show cause of action.
We are not here to scrutinize the witnesses, evidence of the witnesses. We will see whatever has been recorded. Your DW1 is saying what? You just have a look at it.
But only one thing. I will make one submission.
So you say
That's-
that's 5K. Whatever was written in 5K is to admitted
But the plaintiff
by
is
the
coming.
defendant.
It is well settled that when plaintiff is coming, plaintiff has to first prove
That's
her
right.
case.
But you have yourself deposed about 5K.
But first of all, the plaintiff has to prove the case. Plaintiff has to discharge the primary burden is upon the plaintiff, and in terms of section 101, and then it will come to the defendants. And the learned appellate court has committed another illegality, according to the appellate, by considering the defendant's witness as not
What is the
considered.
judgment like in England? कहाँ भेजी है? यार गोराई नहीं करते हैं क्या? वहाँ से भी तो प्रिंट ही निकाल के देंगे ना वो लोग. किताब तो भेजते नहीं कभी. उनको तो खाली प्रिंट करने आता है लाइब्रेरी वालों को. उनको तो किताब निकालने में भारी लगता है. कभी भेजते हैं वो लोग किताब? नहीं भेजते हैं ना? कहाँ भेजते हैं किताब? जब भी भेजते हैं प्रिंट निकाल के भेजते हैं. निकालने में दिक्कत होता है, चढ़ना पड़ता है, वो सब कौन करेगा?
जी
देखिए, और दिलों ने काउंसिल appearing on behalf of the applicant. The counsel for the applicant has submitted that the applicant is the defendant of the suit. The trial court had dismissed the suit by recording a finding that there was no unity of title and possession with respect to the suit property. But the finding has been reversed by the learned appellate court. While referring to the genealogy, he has also submitted that it is not in dispute that the plaintiffs and defendants are governed by the Akshara law. He submits that the property, he has referred to the genealogy to submit that the property originally belonged to Vakar Nath Panjara, who had 2 sons, and the parties are some of the descendants of Karmudhar Panjara. Who had 5 sons, and the parties are the descendant of Devendra Pandyala. The Learned Council has submitted that Devendra Pandyala died sometimes in the year 1975, leaving behind his widow Kamini Pandyala, and he had 3 sons. One of whom died unmarried in 1998. Amulya Chand Pandyala died in 1972. And the plaintiffs are the 3 daughters of Amulya Pandyala. He has also submitted that the sole defendant is son of Devendra Pandyala, namely Sarat Pandyala. The Learned Council has also submitted that Eva Rani Pandyala, widow of Amulya Chand Pandyala, as well as Kamini Pandyala, widow of Devendra Pandyala, both expired in the year 1998/1997. इसमें कुछ clarity नहीं है date of death और finding भी नहीं है.
हाँ, proper
1998/1997.
हम लोग की तरफ से भी उसको कोई डिस्प्यूट नहीं किया गया WS में.
And consequently, on the date of coming into force of Amendment 2, on the date of coming into force of Hindu succession, on the Amendment Act, and consequently on the date of amendment to Hindu Succession Act on 9/9/2005, whereby the daughters were given the status of co-partnership. The surviving descendants of Devennath Pandyala was Sarat Pandyala, a son, and 3 granddaughters, named who were the plaintiffs, and they were all the 3 daughters were married prior to 1998. इसका फाइंडिंग है कि ऐसे ही बोल रहे हैं?
नहीं, ये डिपोजिशन में भी है और जो उनका स्टेटमेंट भी है. PW1 का डिपोजिशन में भी वो फाइंडिंग है, मतलब वो एडमिशन है.
The Learned Council submits that.
पैराग्राफ 40 में आया है
Just-
PW1.
The Learned Council submits that. Accordingly, the entire property devolved around the sole defendant namely Sarat Pandyala, prior to 9/9/2005, whereby the daughters were given the co-custody status.
पैरा 40 में ओरिजिनल प्लेंटिफ का जो डिपोजिशन है उसमें है मेरी शादी 1974 में देवघर में हुई और 2 बहन की शादी आसनसोल दुमका में हुई है. एक बहन की शादी 1976 में और दूसरी 1992 में हुई है. सो 74, 76, 92 ये इनका डिपोजिशन क्रॉस में है.
The Learned Council submits that. Accordingly, there was no unity of title and unity of possession with respect to the suit properties, as the entire suit property devolved around Sarat Pandyala prior to 9/9/2005, and consequently the daughters could not have claimed partition and the status of co-partner. He has submitted that the Learned Trial Court had considered he has also submitted that it was the specific case of the plaintiffs that the plaintiffs had inherited and succeeded like that of defendant and came in joint possession of the sued property on payment of rent, though for the sake of convenience, cultivation and supervision of the sued property, Ibarani Parandiara and Sarat Pandiara separated in mess and property and similarly operated separate cultivation and supervision of lands without final partition by means and law. यही है ना specific case. And the cause of action arose when the defendant has been quarreling with regard to supervision of cultivation and enjoyment of sued property. And the plaintiff demanded and requested the defendant to partition the sued property by means and bound, but the defendant became hostile. The learned counsel has submitted that the appellate court, by reversing the decree whereby the partition suit was dismissed on the ground that there was no unity of title and unity of possession, between the parties, has referred to has observed that the learned trial court ignored the presumption of jointness of the parties and had come to a erroneous finding. The learned appellate court also referred to the amendment dated 9/9/2005, which was subject matter of consideration by the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma, decided on 11/8/2022, reported in bracket 2020 bracket close 9 SSC 1, and held that there was unity of title and possession between the parties and allowed the appeal. The learned counsel has submitted that once prior to coming into force of amendment to Hindu Succession Act dated 9/9/2005, there was only one surviving co-partner. The entire property automatically devolved upon Sarat Chand Pandiara, the sole Sarat Pandiara, the sole male survivor in the family, and therefore there was no question of any partition. He has submitted that the judgment passed by Honorable Supreme Court in the case of Vinita Chandra has been wrongly applied to the facts and circumstances of this case. यही है आपका सारा केस छूट गया. Arguments concluded on the point of determination of substantial question of fact. हम वो judgment पढ़ेंगे तभी हम देखेंगे. If the issue is decided, then I will not tell you the question of fact. There are 2 more judgments which has come up. After this विनीता चल रहा है. इसको clarify भी किया है. वो आप लेके नहीं आए हैं.
इसमें भी ये इशू मोर और लेस कह रहा है 80 81 ये रेलेवेंट हो सकता है हमारे पर्पस के लिए, जो प्रकाश वाला केस को जो ओवरराइड किया गया है.
इसको देखना पड़ेगा. ऐसे नहीं कर सकते. If the issue has been decided, then there is no question of it.
Yes, yes.
If you say that as a council, you can say it has been decided against
No,
you.
it has 80 81 it has been decided. I think it has been decided against us only. It has been.
Let me just have a look at that.
Yes.
लाइए जरा. Para number 80, 81.
हाँ. Paragraph 80 at page 61.
पढ़िए
As
सर.
a finding has been recorded in Prakash that the rights under the substituted section 6 accrue to living daughters of living co-partners as on 9/9/2005. This would have helped us, but this is not good law now. Irrespective of when such daughters are born, we find that the attention of this court was not drawn to the aspect as to how a co-partnership is created. It is not necessary to form a co-partnership or to become a co-partner that a predecessor co-partner should be alive. Relevant is birth within degrees of co-partnership to which it extends. Survivorship is the mode of succession, not that of the formation of a co-partnership. Hence, we respectfully find ourselves unable to agree with the concept of living co-partnership as laid down in Prakash versus Kulkarni. In our opinion, the daughters should be living on 9/9/2005. In substituted section 6, the expression daughter of a living co-partner has not been used. Right is given under section 6(1)(a) to the daughter by birth. Declaration of right based on the past event was made on 9/9/2005, and as provided in section 6(1)(b), daughters by their birth have the same rights in the co-partnership and they are subject to the same liabilities as provided in section 6(1)(c). Any reference to the co-partners shall include a reference to the daughter of a co-partner. The provision of section 6(1) leave no room to entertain the proposition that co-partners should be living on 9/9/2005 to whom the daughter is living. We are unable to be in unison with the effect of deemed partition for the reason mentioned in the latter part. Then this is also may be relevant for our case. In Mangamal versus T.B. Raju, the court considered the provisions made in the state of Tamil Nadu. The state government enacted the Hindu Succession Tamil Nadu Amendment Act 89 made effective from 25, adding section 29A in the Hindu Succession Act 56. Section 29A was held to be valid regarding succession by survivorship. Section 29A provided equal rights to daughters in co-partnership property. The provisions were more or less similar, except 29A subclause 4 treated a married daughter differently. The provisions were not applicable to the daughters married before the date of commencement of the Amendment Act 89. Thus, married daughters were not entitled to equal rights. That too has been taken care. This may be important so far as to counter our submission. That too has been taken care of in section 6 as substituted by the 2005 Act, and no discrimination is made against married daughters. In the said case,
I think there is no question.
yes.
I will just give a short dictation on this, but we'll have an elaborate finding on this. Upon going through the judgment by the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma, reported in bracket 2020, that is 961, paragraph 80 and 81, this court finds that it has been ultimately held by the Honorable Supreme Court that the daughters acquired a co-partnership right by birth, and merely because they were married on the date of coming into force of the amendment to section 6 of Hindu Succession Act, which was made on 9/9/2005, their status of co-partnership does not get lost. Paragraph 80 and 81 of the aforesaid judgment is quoted as alright. This court is of the view that the appellate court has rightly applied the ratio of the aforesaid judgment, and the issue having been settled by the Honorable Supreme Court, no substantial question of law is involved in the present case, which is required to be determined. Accordingly, this appeal is dismissed.
Okay.
Item 11.
80-81 पे quote करेंगे. 80-81.
Item 11, second appeal 219 of 2022.
Judgment of reversal, the respondents are the state here.
Just a minute. Yes. This will be. This respondent at the state.
Yes.
The suit was decreed.
This suit was decreed. We claim, the plaintiff filed a suit claiming that the properties were gifted by registered deeds in favor of a deity, and the plaintiff is a Shabayat of that particular temple, and the entire suit property, it also contains a tank also, Bandh, and they, because the state was settling the said Bandh, treating it as a property of the state, therefore we were compelled to file a suit. This trial court found that the suit property was gifted by way of a registered deed, Arpan by way of Arpan, and those were
By whom?
by the original Khevatdar. That means the original Jamindar. They were gifted.
What is the date of gift?
Only 2 dates are given, but later on we have exhibited actually 4 dates, 4 Arpanamas, but only 2 have been mentioned in the plan. Those are of the year 1923 and 1954.
1954. These are belonging to two different tanks.
No, same, because
The
it was.
property, when the property was gifted in 1954, the land was running in the name of the Dayats.
Yes, this is our claim. Now, from perusal of Arpan, it appears that they had given their share of the property, because it must have been recorded in name of several persons. Therefore, it says that they are giving their share of the land of the tank, and therefore there appears that there are multiple
Undivided
deeds.
share.
Undivided. But there are multiple deeds, and on the basis of that, ultimately the properties were recorded and rent receipts were issued in the name of the plaintiff. But subsequently, when the state was auctioning the tank for a particular period, so that gave us a cause of action, file a suit. The trial court decreed the suit on the ground that the land belonged to the deity and the plaintiff was the Shabayat of that particular deity, and therefore the land could not have been settled by the state. Now the appellate court strangely makes out absolutely independent case. 3-4 places I'll point out that it makes out a case which was not even pleaded by the state or us. It makes out a case and then it.
What third case they have?
Yes. Your Lordship may directly come to the appellate court's judgment. At several places, not only one place. Your Lordship would directly come to running page 35. So here, from para 15, the discussion starts, and then Your Lordship would kindly take note of the bold portion where the learned appellate court takes note of 4A of the Bihar Land Reforms Act. It completely skips this portion of the section 4A where it says, I may be allowed to read this.
Yes, please. Bihar Land Reforms Act.
Yes, yes. As per section 4A, Bihar Land Reforms Act, such estate or tenure, including the interest of the proprietor or tenure holder in any building or part of the building comprised in such estate or tenure and used primarily as an office or kachari for the collection of rent of such estate or tenure, and his interest here I am putting emphasis on it, and his interest in trees, forest, fisheries, jalkars, ghats, bazaar and ferries and other Sairati interest. Sairati interest is the interest in the tank. Sairati interest. So here I'll pause. Now what does section 4A say? That his interest means the interest of the landlord. If prior to enforcement of BLR Act, if the landlord had already transferred his interest, then that would not be covered by section 4A. Because his interest
So
means,
according to you, it's a private tank.
yes, if prior to enforcement of the act itself, if the landlord had divested his right to a deity, then it no longer remained a property of the landlord. And therefore, Your Lordship, after 4 lines also, again this particular line has been mentioned, that so and so, and also his interest in all subsoil so and so, after 4 lines, other than the interest of Rayyat and under shall with
exclusion.
effect from the date of vesting so and so. But what he does, he says now that I further find that 4M no description of suit land has been mentioned. I further find that it has been pleaded that Panchulal Dusandi was Khevatdar of Khevat number 7, but this Khevat is Ejmal Khevat, meaning thereby Panchulal Dusandi was not the sole Khevatdar, proprietor, tenure holder. Rather, there were other Khevats, which is also crystal clear from Khatyan of Khata number so and so, and as such he had no right to solely execute Arpannama, which has been marked as Exhibit 1. I further find that this Arpannama is dated 28/1/1923. As per this Arpannama, Panchulal Dosandi executed the same in favor of Sri Lord Shiv Thakur, Jiv, wherein and whereunder he made himself Shabayat of the deity and described that after his death, Vaikuntnath Dosandi, his nephew Bhatija, would be Shabayat. I further find that Arpannama dated 17/9/1954 has also been brought on record on behalf of the plaintiff respondent, which has been executed by Vaikuntnath Dosandi, wherein and whereunder he has been appointed Shruti Kriti Devi as Shabayat of the deity. But in this Arpannama, description of suit property has not been mentioned. I further find that neither khata number nor plot number has been shown in this Arpannama. I find that the certified copy of the order dated so and so has also not been brought on record on behalf of the perusal of the same. I further find that so and so. May I'll read or I'll only point out? Yes. I'll point out where he has actually made out the fact. I further find that the plaintiff has filed an application for settlement of the tank after dismissal of the appeal. Instead of filing revision before the commissioner, he filed title suit number so and so and claimed title over the tank and its aisle, which is self-contradictory and defeating the claim of the plaintiff respondent. Not only this, I further find that R.S. Khatyan Khata number 91 has been brought on record on behalf of the defendant, which has been marked as Exhibit A, and from perusal of this document, it is crystal clear that the same was finally published on 21/9/1992 and in the name of Anabad Bihar Sarkar, but the plaintiff never filed any objection before the survey authority as provided under section 83 and 87 of the CNT Act, and has filed the instant suit on 25/8/2005 but no relief has been claimed against Divisional Survey Khatian. I further find that the plaintiff is claiming himself a Shabayat of Shiva Mandir situated as Bagaspura, PS Govindpur, and has brought the suit without making the deity as a party in the suit, though deity is a legal and juristic person and he has not been made a necessary party. So here I'll pause. Two things I'll point out. First, the appellate court says that I did not file any objection under section 83 and 87 of CNT Act, although the land was recorded as in the record of right in the name of Anabad Bihar Sarkar. This is absolutely misconceived in view of the fact that after final publication, it only carries a presumption of correctness. That is all. But in a separate suit, I am not required to seek a declaration that with regard to, or even if I did not file any objection under section 83 and 87, that only the consequence would be that it would carry a presumption of correctness, nothing else. But it would not be a conclusive proof. Whereas subsequent portion of this same judgment, I'll point out that the appellate court treats this as conclusive. And subsequent portion I'll point out. Second, here the third case has been made up, where the appellate court says that I further find that the plaintiff is claiming himself as Shabayat of Shiva Mandir situated and so and has brought suit without making the deity as a party in the suit, and though
Your
this
status as Shivayat was not in dispute?
not in dispute. It was not in dispute, and no issue framed, no point for determination framed by the appellate court. So how this point could have been taken in the appeal, making out a third case against me?
Non-joinder.
Non-joinder.
That was not the issue.
Not an issue. Absolutely not an issue. Non-joinder of deity. Then he says, I'll read out further.
And these registered documents are not in dispute.
No, only the consequences.
What is
What
the
would be the
consequence
consequence?
of the one more thing they have taken, that you have the gift was of undivided portion of the property.
But
Then how
yes,
and
yes,
to what
absolutely,
extent?
absolutely. I do get this. There are certain things which are against me also. I had made a specific case in my plaint with regard to mentioning therein only two urban numbers. But actually I had produced 4. And the other 2 which were marked as exhibit were exhibit 1 by B and 1 by C.
That
And
completed the entire
yes,
property.
yes. Therefore, now your Lordship is aware that in pleading what am I required to state? I am only required to state
That
the
you are the owner of the
fact and not the evidences by which I become a. So these 2 were the evidence.
Has the court drawn any adverse inference against you on account of production of further?
No, it has only discarded exhibit 1 by B and 1 by C, saying that this has not been pleaded by me
Need
in my
not
plea.
be.
Yes, therefore, but
Because once you claim title,
absolutely,
what is the source of title
absolutely,
can be
absolutely. But
can
but
come through evidence.
I must
I don't know.
also fairly point out that my only error as a plaintiff was that I had mentioned only 2 arpannamas in my plea, but I was not required to state.
You claim the entire property
Yes,
to have
yes,
been
absolutely,
gifted,
absolutely,
the entire
absolutely.
property.
Yes, and therefore
Then
entire
how could you get arpannama of other co-rayats?
there were 2 other
It was executed by other co-rayats.
persons which was not taken into account by the first appellant, which was discarded solely on the ground that I have not pleaded with regard to these in my plaint, and this could not have been discarded in view of the fact that
What was the relief prayed for in the plaint? So you claim the entire tank.
yes, entire. I was just trying to get to that portion where
It
the
is there in the decree. The prayer is quoted in the decree.
quoted in the decree, but the appellate court has discarded those 2 exhibits only on the ground that I have not pleaded. That portion I was searching.
Yes, respondent, although you have no role to play at this stage, what do you say? Does all the surrogates they become government property, or they can be private land also?
which are mentioned in record of rights as government land.
No, who will mention it? Government that entry in record of right will be a declaration of title, or if there are
On account of vesting, if it is not mentioned in Form M, and even in Form M, there are, it's appellate court, even the appellate court has meticulously examined the records and documents, evidences. And what it has found that things which were on record suggests that the person who has given this Arpan-nama, whether he was empowered to do so or not, that was also
he
a
was the
matter.
recorded player.
He was not the sole. Property was
No, but the Arpan-namas which were produced covered the entire property and executed by different persons.
executed by.
If there are in a suit, they are claiming title with regard to the entire pond. The pond was recorded in name of 4 persons. Maybe. They referred only to 2 deeds and claimed the entire property. And in the evidence, they came up with 2 more deeds. Is there any bar in law?
That is not even. That is not the fact that.
Is it a fact that the entire property stood covered by the 4 deeds?
Even the appellate court has not taken note of all those two deeds which were not pleaded. The fact is that it has taken note of the deed which was Arpan-nama, that is Arpan-nama which was issued by the plaintiff. That person is named as Dasodi, and he has in 1923 itself he has issued this Arpan-nama solely because
He is the person who had gifted the property.
but he was not sole empowered to gift that property because that he was a Khevatdar.
Undivided share he can't gift.
Not undivided, he has given entire. He was the Khevatdar and Khevatdar of Ismail property, Ismail Khevatdar. The appellate court has.
What is Ismail?
Ismail means having other share also in a property.
So he gifted the property on behalf of others also.
Yes, that the appellate court says that he solely gifted the property.
You see, it's a judgment of reversal. It will require scrutiny of some of the evidences made.
Definitely.
What substantial question of law have you
Yes,
said?
Your Lordship, that whether the appellate court could have made out a third case which was not even pleaded by both parties, because the judgment of the Honorable Supreme Court in Badshah Nahar is that the court has to decide the matter on the basis of pleading of the parties. It has to confine itself to the pleading of the parties. At several places, I'll point out that the appellate court has made out a third case. And strangely, the appellate court in next page also, it takes note of, if page 38 your Lordship would see, 38 also, again after 2 lines, I further find that it is also a fact that one petition under order 1 Rule 10(2) was filed by the son of Shruti Devi so and so, Rishikesh, claiming herself to be Shabayat and making him a party. It shows that the present respondent is not alone heir of so and so. All these were not there. How can the court enter into a question, particularly when on the basis of a petition under order 1?
So there are multiple points on which,
Yes.
according to you,
And
the court had gone beyond the
beyond
case of the
pleading,
respective
beyond
parties.
pleading of the party.
So, but it has to be specifically enumerated in the substantial question of law, or you will argue at that present and whenever that. Because with substantial question of law, are you referring to so far as this is concerned?
No, I don't think that your Lordship at the time of drafting.
The trial court judgment has not been considered by the appellate court.
That has been considered.
It only says what it says. It does not discuss. It only says in para 16. Para 16, page 41. Before that, all other findings are there.
But
After
the
due, I
reasoning has not
find
been
that
dealt with. The reasoning has not been. Where is the consideration of reason by the
Reasoning
applicant?
has not been given, it has been short definitely. That how the order of law the trial court is met in. That is not. But yes, documents and evidences have been discussed in it.
No, but the trial court is citing reasons, no? For this.
Trial court is citing reasons.
Citing reasons referring to Form M,
Yes.
showing that it
And
stood in the name of the
that's why-
mother.
That's why the Form M was disputed by the appellate court. That Form M does not include any description of land. And even the judgment of this honorable court that mere inclusion in Form M will not exclude the property from registry. So all these things have been discussed. Yes, definitely. Evidences and documents have been discussed in detail by the appellate.
May I point out one more thing? Your Lordship would recollect, one matter is before Your Lordship on first appeal, which was remanded by Honorable Supreme. And the appellate court has relied on the judgment which has ultimately been actually with the consent, although we had agreed for remand. But in that, the Honorable Court in first appeal judgment which has been relied by the first appellate court, in that judgment the Honorable Court had held that even if a particular property is mentioned in Form M and it is of Saira, that means a tank, it would not issuance of Form M with regard to that property would not become a private property of the plaintiff of that suit, and the Honorable Court had declared it to be a state's property. But that judgment was ultimately, with consent or whatever, it was set aside. So that Your Lordship would find in page 36 of the judgment.
You see, it's a judgment of reversal. So these things are certainly required to be considered. But if the point of law is not properly formulated, then
I'll
then
frame
we are.
exactly, I'll frame, but there are 2-3 places
You
where
can do
the
one
appellate
thing. You
court.
can do one thing. You
Yes.
can come back by 4 o'clock also.
Yes.
Please frame it properly.
Absolutely.
And you should specifically
Absolutely.
indicate
How the
as to
appellate
how
court-
the appellate court has
Yes.
gone, on what
Yes.
finding the appellate court has gone beyond.
Absolutely.
Because the better the question of law is framed, the better would be the answer.
Absolutely.
वेग क्वेश्चन का वेग आंसर होगा.
Yes, yes. I
ठीक है. रीजनिंग नहीं मीट किया है, that is one question. Because reasoning नहीं मीट किया है.
No,
As such.
he has not.
ठीक है, not made the reasoning, not said that this is wrongly, this reason is wrong or whatever, right? And उसके अलावा ये जो beyond आप बोल रहे हैं, ठीक है,
Beyond pleading.
beyond pleading,
Yes.
and then if anything else, if you want to indicate, you just indicate. We'll frame the question of law.
Yes.
accordingly. You extend both of you. ये तो
It says that
reversal है इसमें तो it has to be heard.
it says that the entry in Khatyan is the conclusive proof.
हाँ, तो वो सारी
How
चीजें
can
आप
it be
नहीं, अगर
conclusive?
आप
That is the
substantial
judgment
question
of
नहीं
Allah.
आप ढंग से
Allah.
बनाएंगे तो कैसे होगा?
It has been
Allah.
mentioned based upon judgment of this honorable court, referring the judgment of this honorable court.
Which is that judgment? It says that entry in Khatyan is a conclusive proof.
That is mentioned, definitely needs
कौन सा
to be.
बताइए ना, कहाँ mention?
ये पेज नंबर 38 में मेंशन किए हैं.
In the running page.
हाँ, 38.
नीचे से approximately 7-8 lines.
It's a conclusive proof of possession.
हाँ.
Title थोड़ी.
The possession, the point is that now they are claiming in fact possession, so far possession is concerned, that is also mentioned that since 1992 it is a possession of state government. On record.
1992 से.
On record मतलब वो
Adverse possession आपको claim करना है क्या?
1992 से हम उसको सेटल करते आ रहे हैं.
हाँ ठीक है, वो आप
2005
करते आ
में
रहे
पहली
हैं.
बार सेटल नहीं
आप
किए.
state अभी judgment नहीं देखे. State cannot claim adverse possession.
नहीं, हम एडवर्स पोजीशन का
Merely
claim नहीं
because
करते.
you have settled it for a number of years, that will not give you title.
हम सेटल सिर्फ सेटल ही मतलब वो इनफैक्ट ये भी आया है रिकॉर्ड में कि ये हमारे पास आए थे कि हमको सेटल कर दीजिए,
नहीं
जब वो रिजेक्ट हो गया
कोई बात नहीं, रिजेक्ट हो गया, इससे क्या, इससे एडवर्स पोजीशन थोड़ी
वो रिजेक्ट
आपका बन जाएगा.
दैट मींस कि इनके पास इनका ये कहना कि ये मेरी प्रॉपर्टी है,
इट इज एब्सोल्युटली इसे एस्टॉपल लगाएंगे आप,
नहीं, हम वो नहीं कह
तो
रहे हैं.
वही तो लगाया है अपीलेट कोर्ट ने. ये खुद आके सेटलमेंट करने के लिए रिजेक्ट हो गया, इसीलिए हिज कंडक्ट
That
इज
is
नॉट
not the only ground. That is not the
दैट इज
only
वन ऑफ द ग्राउंड. तो ये सारी चीजों को आप ठीक से नहीं बनाइएगा तो कैसे होगा. यू जस्ट फ्रेम दीस क्वेश्चंस प्रॉपर्ली. आप आइए 4 बजे, इसको ठीक से आप लोग एक्सचेंज करके एक बार आ जाइए, ठीक है, और रिकॉर्ड कॉल फॉर करके डिसाइड कर देते हैं इसमें करना क्या है. आप हैं ही यहाँ पर, तैयार हो जाइए, इतना तो सुन लिए.
Conclusive word,
देखिए,
it is conclusive with regard to
my
publication.
concern is if the substantial question of law is not properly framed,
Yes, Allah.
answer will not come proper.
I'll
उसके बाद फिर सुप्रीम कोर्ट तक
Absolutely.
कहानी
नहीं,
चलते
नहीं,
रहेगा,
I'll-
इसीलिए
I'll-
प्लीज डू दैट.
I'll do it.
ऐसा नहीं, 4 बजे तक आ जाइए.
Yes, I'll.
आ
Second
जाएंगे?
half. In second half.
सेकंड हाफ में
Yes.
4 बजे तक, हम तो 4:30 बजे के पहले
ठीक है.
उठते नहीं.
I'll-
आप आ जाइए. हाँ, ऑर्डर्स 4 बजे होता है, 4 बजने में 5 मिनट हैं.
ठीक ठीक.
ठीक है मिस्टर राहुल. 5 minutes to 4.
Item 12, second appeal 11 of 2023.
This case I played for some time.
Few times.
There is some function in the today 10 बजे आज आए ही हैं. इसको 10 दिन के बाद कोई भी डेट दे दिया जाए. After 10 days कुछ फंक्शन है घर में. 18th को रख दिया जाए.
आपका सब डिफेक्ट रिमूव हो
हाँ
गया.
सब डिफरेंट.
किसी का डेथ रिपोर्ट नहीं.
नहीं इसमें अभी नोटिस हुआ है किसी को. 18th को खाली रख दिया.
रख देंगे 18 को, जरा देखने दीजिए क्या मैटर है. पार्टीशन सूट पर डिक्रीड और डिसमिस.
डिसमिस. पार्टली अलाउ हुआ है, पार्टली ये तो ये इंटरवेनर के ये में फेवर में कुछ हुआ है, उसको चैलेंज हुआ है. देयर आर 3 सेट ऑफ अपील फाइल्ड बिफोर द अपीलेट कोर्ट.
तो 3 सेट के अपील में से एक ही
अपीलेंट जो प्लेंटिफ है वही फाइल किए हैं. बाकी लोग का कोई स्टेटस नहीं है. फाइल
तो पता करते हैं ना.
पता कर.
बताइए जरा, इसमें से जरा देखेंगे कि एक ही साथ डिसाइड हुआ था.
एक ही साथ कॉमन बाय कॉमन.
इसमें से जरा देखिए
Common
कितने अपील
judgment.
फाइल हुए हैं. कितने पार्टी हैं भाई इनको तो.
सो मेनी पार्टी.
ये जरा देखिए तो 1980 का पार्टीशन सूट.
ये टाइटल अपील नंबर 33, 35 एंड 40 3 अपील हुआ था.
अच्छा,
हम
ये
35
देखिए टाइटल अपील नंबर 33, 35 एंड 40
of 2012.
और 2012. ठीक है, ये डिसाइड हुआ था लर्नेड डिस्ट्रिक्ट जज रोमन 9 देवघर. तो ये जो टाइटल अपील का नंबर दिए हैं, ये इससे केस का नंबर मिल जाएगा, थोड़ा पता कर लीजिए. Learned counsel for the appellant has submitted that by common judgment 3 title appeals were decided. Title appeal number 35, 33, 35 and
40 40
33, 35 and 40, all of 2012. The present appeal is relating to title appeal number 35 of 2012, and he is not aware as to whether any appeal has been filed arising out of other title appeals. prays for some time to prepare himself in this manner. Post this case on, आप अपने से पता कर लेंगे, पता हो जाए तो उसको बताएंगे।
I was searching online,
नहीं पता चला।
unable to get.
Post this case on. (18th of March).
Yes.
18th of March 20.
Item 13, 2nd April 25 of 2023.
Up to that?
Your leadership, in this we have applied for the certified copy of exhibits and
So,
we need some time for this.
for substantial question of law, you don't need certified copies of reports. For substantial question of law, you don't need such certified copy because that is not your case. That it has not been properly appreciated or there is any perversity.
Leadership, we have to prepare that by documents.
No, it can't be like this.
Then it may be partial resolution and not as well.
There are concurrent findings by both the courts, and you are the plaintiff appellant, isn't it?
Yes.
Yes. What was your suit for?
Leadership file is not it may be partial resolution.
You stand in a court without a file.
Leadership, some wrong file has been.
Sorry?
Some wrong other file has been.
Which file? Show me a file.
It's Raghunath Mehto.
So why are you standing? You don't even have the file. You can't even answer the basic question.
This
Let me discuss it for default. Why are you standing? ये जो आप बोल रहे हैं ना कोई फाइल लेके खड़े हो, ये हम लोग को ट्रेनिंग में बताया जाता था कि फाइल नहीं हो तो कोई फाइल लेके खड़े होना चाहिए. Wait, क्या?
maybe by mistake because the petitioner name is
आप तो
same.
इतना देर से यहाँ बैठे थे, आपको नहीं पता केस का क्या नंबर है?
I've just
No. You were sitting over here. I saw you.
just
छोड़ दीजिए, आपके केस को डिसमिस कर देते हैं. आपका अपीयरेंस रिकॉर्ड करेंगे नहीं करेंगे?
then it may be partial resolution by Congress.
बुलाइए अपने सीनियर को. ये सब राउंड के चलते यहाँ पे टाइम नहीं होने वाला. सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करना होगा ना, उसके लिए आपको इतना एग्जिबिट छानने का जरूरत नहीं है.
Item 14, 2nd April 33 of 2023.
Are you there in this case?
Well, I will also take time allowed for preparation. Plaintiff suit filed for declaration of his title on the basis of registered deed of sale has been dismissed. Now, prayer was made. Defendant number 4 was housing society. that defendant number 4 has purchased the suit land from defendant number 1. This is admitted case of the party. Now
You
defendant.
want to argue or what?
No, my lord, I gave some time, my lord. Just giving my lord, since my lord always know that what is the merit. So there is concurrent finding on both the points, my lord. So my lord, that's why I am paying some time, my lord, for
तो एडवांस सर्कुलेशन नहीं है, कुछ नहीं है, आप तो वैसे ही सिर्फ टाइम मांगेंगे तो कैसे चलेगा? तो हमेशा बहस करते हैं, तो क्यों ऐसा पड़ता है?
नहीं, I am not.
तो ऐसे टाइम नहीं मांगते?
नहीं, टाइम नहीं मांगते, लेकिन अगर my lord I will not properly assist my lord, then it will be a tough situation.
अब आपको हम टाइम दे दें, दूसरों को ना दे तो क्या मतलब
नहीं,
आर्टिकल 14 का
Like,
वायलेशन?
well, I am just saying that my lord, if my lord, I have seen the judgment, both the judgments. Now, my lord, in both the judgments, sentence of both the parties have been compared. Now, but without looking into entire thing, well, I will not be in position to submit because I always argue fairly, my lord. If I have no case, I will say, my lord, this is very true.
ऐसे नंबर 30 कल रख देते
नहीं, कल नहीं.
फिर कब?
नहीं, 2 वीक का टाइम दे दिया जाए, हम देख लेते हैं, उसके बाद हम फेयरली करते हैं. कल फर्स्ट अपील फिक्स किया हुआ है माय लॉर्ड का ही, उसमें हम लोग हैं स्पेशली फिक्स किया.
जितना भी जो एब्सेंट हो रहे हैं सब फाइनल डिस्पोजल में एक करके हम फिक्स कर देंगे.
कोई दिक्कत नहीं.
उसके बाद बस ये जो बॉटम ऑफ द लिस्ट चलते रहता है ना, एक आध डेट होगा, हो ही जाएगा, क्या होगा?
नहीं, हम लोग कर भी देते हैं.
ऐसे नंबर 33 और 2023. The learned counsel for the applicant prays for time to prepare this case. He submits that there are concurrent findings recorded by both the courts, and the plaintiff is the appellant registrar, who was claiming
His time.
title by virtue of registered city.
Deals.
He has also submitted that the defendants were also referring to registered cities. He submits that he needs to go through the syndics and put last sentence. At his request, pose this case on tenth of March for final decision. नहीं, 10th of March to be taken up at 10th March को रखते हैं.
हाँ.
चलिए 10 मार्च को खाली ऐसे ही रखते हैं.
हाँ, सर. ठीक.
Item 15, second appeal 42 of 2023.
This case has to argue by Mr. Ashok Kumar Sinha. He is went to Kolkata for his treatment of his wife.
कब रखने बताइए?
After 1 week also.
ऐसे नंबर 42 और 22. मिस्टर नाम बताइए.
Sumit Anand.
Mr. Sumit Anand, advocate, has submitted that this case has to be argued by Mr. Ashok Kumar Sinha, the advocate on record, but he is not available as he has gone out of station for treatment of his wife. He prays that the matter be posted in the next week. Post this case on next Monday.
Next Tuesday or next also.
Monday से भी शुरू नहीं होता.
Monday 3 and
Wednesday को आके पढ़ेंगे ना थोड़ा. Post this case on next Wednesday. Wednesday. छुट्टी है. Wednesday छुट्टी है. Thursday. छुट्टी नहीं है क्या? नहीं, छुट्टी नहीं है. Wednesday.
Item 16, second appeal 194 of 2023.
देखिए ऐसे number 194 of 2023. Nobody appears on behalf of the appellant by order dated 29/10/2024. The prayer for time was allowed by way of last indulgence. the considering the interest of the party. However, the matter is adjourned and is directed to be posted on next Wednesday, subject to payment of cost of rupees 10,000. The 10,000 in the name of advocate. Cost लगाने वाले.
नहीं हम जस्ट दूसरे कोर्ट पे तुरंत.
चलिए. हाँ बताइए क्या होगा.
रशि वन थिंग आई वाज सबमिटिंग इसको उधर सिर्फ मंडे को रखा जाए.
नहीं देखिए अभी हम आपको 10,000 रुपए कॉस्ट का ऑर्डर कर चुके
नहीं
हैं. वेडनेसडे को बोलिएगा रख देंगे 10,000 रुपए पेमेंट कर दीजिए हमको कोई.
नहीं पढ़े नहीं उधर इसलिए कह रहा हूं.
पढ़िए
फिर सबमिशन कर रहे हो उधर पास.
साथ पढ़ते हैं कोई बात आराम से पढ़ेंगे ठीक है. पहले हम लोग देखते हैं क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ तो सोच समझ के बनाएंगे ना. पहले वहीं से शुरू कर.
यस.
उसके बाद केस ऑफ प्लेंटिफ डिफेंडेंट पढ़ेंगे और इश्यूज को पढ़ेंगे.
ये इविक्शन सूट का नॉट मच.
Eviction suit.
बहुत स्कोप नहीं है हुजूर.
ठीक. बताइए सब्सटेंशियल क्वेश्चन ऑफ लॉ.
With a judgment and decree passed by land trial court as well as land appellate court, purpose and suffers from non-consideration of relevant material facts and record the same is against the mandate of the law. B is important question. The land trial court as well as land appellate court did not appreciate the fact that the plaintiff was not the original landowner of the suit premises, and his father and after his father's death has left behind as many as 7 legal representatives. And therefore, the plaintiff had no occasion to file the suit as against the defendant.
ये सब प्ली नहीं चलेगा.
हाँ, that is.
ठीक. चलिए आगे बढ़ते
I'm fairly submitting everything
I
what
know.
Lordship is saying. And as well, the court did not appreciate the fact the plaintiff had other premises where the son
ये
could not be.
bonafide requirement.
That is also. But see, what I am submitting in this case, if Lordship grants me some time, we'll be vacating the suit premises. On that point, Lordship, I was submitting. Since Lordship, I know what is the fate of my case. It is a eviction suit. My shop is running there. It is a kapde ka dukaan, running for last more than 30-40 years, Lordship.
How much time do you need to evict? आपका अंडरटेकिंग रिकॉर्ड करके हम लोग
हाँ रिकॉर्ड
आपका अंडरटेकिंग रिकॉर्ड करके
एकदम 6 महीना दिया जाए हुजूर हम कर देते हैं. हम ज्यादा नहीं मांग रहे हैं. 1 साल नहीं मांग रहे हैं क्योंकि कपड़े की दुकान है. इट इज अ वेरी
एग्जीक्यूशन केस का क्या स्टेटस है?
अभी चल रहा है हुजूर. अभी तो ऑर्डर देखिए जस्ट क्लाइंट इज आल्सो कम लॉर्डशिप को बोलेगा तुम ले आएंगे. सेकंड हाफ में रखा जाए.
बहुत ज्यादा है. सेकंड हाफ में रखते हैं 6 महीना बहुत ज्यादा.
उसको बोल दिया
6 महीना इज टू लॉन्ग.
द ऑर्डर शीट हैज कम लॉर्डशिप. वो रेट इशू करना है आज ही का डेट दिया.
अब ऐसे में हम आपको इस तरह का ऑर्डर करते हैं
तो लॉर्डशिप हम हुजूर
डिसाइड करना है.
हम हुजूर पे छोड़ देते हैं.
ऐसा ठीक नहीं लगता.
हम हुजूर पे छोड़ देते हैं. आज इशू रेट इशू करेंगे तो 3-4 महीने ऐसे ही. हाँ. Therefore, I am submitting Lordship reasonable time. Whatever Lordship sees, Lordship fixes. Whatever Lordship fixes.
In absence of other side, second appeal में बिना substantial question of law बनाए.
It can be disposed
The
of.
law will not permit.
That is true, Lordship.
जो चीज हमको लॉ परमिट नहीं करता है ना वैसा ऑर्डर मत करें क्योंकि फिर वो ऑर्डर हमारे ऊपर तो बाइंडिंग हो जाएगा ना. दूसरे पर नहीं होगा.
इसमें जो क्या होगा कि he will also have a mindset कि हमको इतने तारीख तक का हाई कोर्ट का आदेश हुआ है. I have to evict it. Otherwise लिंगर होता है. दोनों पक्ष को परेशान.
देखिए डिलीवरी ऑफ पोजीशन होने के बाद भी बहुत टाइम लगता है.
तब इसको जो मंडे को रख दिया मेरिट पे कर देते हैं. डिसाइड हो जाएगा. He will also be satisfied कि my second appeal has been dismissed.
नहीं हम तो 10,000 रुपए कॉस्ट के बिना एडजर्न भी नहीं.
नहीं कॉस्ट नहीं किया जाए. कहाँ से कॉस्ट देगा. ऐसे भी इसको
हम तो एडजर्न हम तो कर ही
नहीं.
एडजर्नमेंट आज तो एडजर्नमेंट पे कॉस्ट किसी को नहीं लगाया अभी तक. कोई आप ही मिले.
नहीं हमको भी नहीं लगाया जाएगा.
देखिए एक केस में
हम
प्राइम फेसी कुछ मेरिट थे.
थर्सडे को ही हम रखते हैं हुजूर. पर थर्सडे को हुजूर के पास में 2-3 सेकंड अपील है और 2-3 और लगा हुआ है.
बहुत मान्य.
Therefore, हुजूर हम मंडे
आप कल के लिए रखें.
कल क्या है.
कल छुट्टी नहीं है.
बहुत
नहीं नहीं तो 10,000 रुपए कॉस्ट दीजिए हम आपको अगले दिन.
तो उनको तो आप आई एम नॉट गेटिंग एनी बेनिफिट लॉर्डशिप.
यू आर गेटिंग अ बेनिफिट.
द सेकंड हाफ में उसको रख देंगे.
आइए उनके सामने कर लेंगे, ज़्यादा ठीक रहेगा।
हाँ।
अगर आने वाले हैं तो करें।
No, he is already here. Second half will come live.
सेकंड कोई as such grounds पे तो
No,
कोई
no, grounds.
merit नहीं
I
है।
know what is the fate of this eviction cases, and in both the courts I have lost.
Item 17, second appeal 196 of 2023.
पास होगा तो इसको सेकंड हाफ में रख दिया
ये
है।
सेकंड हाफ आज नहीं हो सकता, आज हम
Second half-
ऑलरेडी 3-4 केस फिक्स कर चुके हैं।
हाँ, उसमें हम लोगों का भी एक मैं पहला मैटर फिक्स
हम तो फिर ऐसा नहीं होगा ना, अब आप ही का केस थोड़ी सुनेंगे, पहले एडजर्नमेंट हुआ है आपको, आपके सीनियर आपको फाइल पढ़ने नहीं देते क्या? पढ़ते हैं कि नहीं पढ़ते?
वो भी रेडी होगा।
हाँ
रेडी होगा
क्या चीज़?
चूँकि 215 में फर्स्ट मैटर जो है फिक्स है, इसलिए उसमें रेडी होगा।
उसमें कौन रेडी होगा? आपके सीनियर ना, आप किस में रेडी हैं? वो तो आपके सीनियर रेडी है, आप किस में रेडी?
मैं इसमें बताता हूँ।
हाँ बताइए, क्या मैटर है बताइए।
नॉट हम लोग इसमें प्लेंटिव थे और अब अपीलेंट है। एक कॉन्क्रेंस का मैटर है, शॉर्ट वैल्यू 5000 है। लॉट second appeal arising out of adjournment dated 23rd of May 2023 and decree sealed and signed 6th of June 2023.
What was the suit for? सूट क्या चीज के लिए फाइल किए? बताइए, सूट क्या चीज के लिए फाइल किए? पार्टीशन सूट। इश्यूज क्या बना?
My lord, suit brought by the plaintiff for a preliminary decree be passed in favor of the plaintiff and against the defendant, declaring the plaintiff's right over the suit property described in the schedule first of the plaint to extent of 2/3 share, and for the final decree in terms of the aforesaid preliminary decree be passed and separate takta be created after appointment of an Amin commissioner.
There was a previous partition. Yes or no? पढ़िए आप इशू नंबर 7, 8 and 11। इशू नंबर 7, 8 and 11, करेक्ट? पढ़िए फिर पैरा नंबर 12 पार्टीशन सूट पढ़िए। पढ़िए पढ़िए। पढ़िए ना।
जजमेंट ट्रायल कोर्ट का।
हम ट्रायल कोर्ट के बिना एपिलेट कोर्ट का जजमेंट नहीं पढ़ते।
यस।
पहले ट्रायल कोर्ट। पैरा 12 इंटरनल पेज 30। धीरे धीरे पढ़ते हैं। ठीक है, आराम से।
Yes, my lord. Issue number 7, 8 and 11. All the three issues are interlinked, hence taken together. The suit lands stand recorded in the Ganges Survey Khatiyan Jamabandi as Kamat, Malik of the then Ghatwal tenure holder Shyama Charan Lal with Radhika Prasad and he Lalter's wife Revati Kumari as her postdar who were entitled to get 150 mounts of paddy every year as Kharpos from the Ghatwal Shyama Charan Lal out of the produce of the suit lands according to the Ganges survey. Khatiyan interred with the judgment dated 14th of November 1932, part by the ASO in objection, suit number 489 and number 490 of the years 1931, with a condition imposed by the said judgment that in case the Ghatwal would fail to give Radhika Prasad and Revati Kumari the aforesaid paddy as Kharpos, they would be entitled to same khas possession of Jamabandi 36K lands from Ghatwal Shyama Charan Lal through the process of civil suit wide exhibits F1, F2A, 1 and 3. The words Kamat Malik mean ownership and possession of the Ghatwal Radhika Prasad and Revati Kumari jointly brought title suit number 108, 1965 in the court of subject Devghar against Thakur Shyama Charan for taking possession of Jamabandi number 36K lands alleging Thakur Shyama Charan's default in giving the aforesaid Kharpos paddy to Radhika Prasad and Revati Kumari. Radhika Prasad had died pendant light. The suit was decreed on 15th of November 1968 in favor of Revati Kumari along wide exhibits 4 and 4A. Thakur Shyama Charan referred first appeal number 22/1969 in the Honorable Patna High Court from the decree passed entitled suit number 108/1965 against Revati Kumari alone as respondent who also died before the decision in the appeal. On Revati Kumari, death Kameswar Prasad Lal, father of plaintiff number 1 and 2, and Bindeswari Prasad Lal, father of plaintiff number 3, 4, 5 and 6, contested the appeal against Thakur Shyama Charan as the legal representative of Revati Kumari deceased as per leave granted by the Honorable Patna High Court Exhibit 5 and confirmed by the Honorable Supreme Court of India Exhibit 6. However, appeal number 22/1969 preferred by Thakur Shyama Charan and contested by Kameswar Prasad and Bindeswari Prasad was allowed by the Honorable Patna High Court, and the judgment and decree passed by the subject in TS number 108, 1965 was set aside and the suit dismissed by judgment dated 27th of August 1980 passed in first appeal number 22/1969 Exhibit 7 and B PW1. This witness, however, admits at para 20 of his deposition that names of Radhika Prasad and Revati Kumari have been recorded in the Ganges survey Parcha of Jamabandi number 36K as Kharpos Das, receivers of maintenance of Shyama Charan Lal entitled to receive paddy owing 150 mounts every year. The witness had admitted that Kameswar Lal and Bindeswari Lal had contested the appeal number 22/69 as legal representatives of Radhika Kumari. The witness has admitted that Thakur Syama Charan Lal continued his possession of the suit property after the Patna High Court's decision in appeal number 22/1969 by para 23 of the deposition. The result was that Kameswar Prasad Lal and Bindeswari Prasad Lal did not recover possession of the suit lands from Thakur Syama Charan Lal as heirs of Revati Kumari and Radhika Prasad, and thus Thakur Syama Charan Lal continued to hold the title of interest and possession over his Kamat Malik lands unvetted as the Kamatdar
पूरा
during
प्रीवियस हिस्ट्री है आपका पूरा लैंड का सूट का, तो फिर अब क्या बचा है कॉन्करेंट फाइंडिंग में? अब कौन सा क्वेश्चन ऑफ लॉ,
Pure question of law.
कौन सा प्योर क्वेश्चन ऑफ लॉ इसमें इन्वॉल्व है?
Lord, may kindly see the substantial question of law which I have.
बताइए
Lord,
कौन सा सब्सटेंशियल?
further.
पहला
Whether the learned appellate court, while passing impugn judgment and decree, it is at page 14, failed to appreciate that immediately rights of Syama Charan Lal in the suit property.
को मिला पेज नंबर
14. Memo.
पेज नंबर 14
1.
बताइए
Whether the learned appellate court, while passing impugn judgment and decree, failed to appreciate that immediately rights of Syama Charan Lal in the suit property, which is a Kamat land, vested with the government by virtue of notification issued by government under 3A of Bihar Land Reforms Act 1950, and the suit property would be deemed to be settled in the name of Radhika Prasad and Revta Kumari, Parcha holders, Exhibit 2 by fiction of law. Second matter, whether the learned
प्लेंटिफ कौन थे, किसके डिसेंडेंट थे?
जी
प्लेंटिफ कौन थे?
प्लेंटिफ हम ही
राधिका
नहीं, राधिका प्रसाद और रेवती कुमारी के ये सब लीगल हेड्स।
डिसेंडेंट्स आर द प्लेंटिफ्स।
एक 66 में सूट फाइल हुआ और रिकवरी वो सूट डिग्री हो गई। इसके बाद उसके खिलाफ अदर साइड ने अपील किया था, उसके दौरान ये दोनों का डेथ हो गया।
अपील तो अलाउ हो गया था ना?
हाँ, अपील अलाउ हुआ था, लेकिन ड्यूरिंग द प्रोसीडिंग जो है तो इनका डेथ हो गया था दोनों का। इसके बाद ये जब लीगल एड्स के लिए पिटीशन फाइल किए, वो पिटीशन जो है सो अलाउ, उसको इन्होंने एपेक्स कोर्ट तक कॉन्टेस्ट किया, उसमें माना कि नहीं दे आते लीगल एड्स। इसमें हमारा इसमें मुख्य बिंदु ये है कि पर्चा में पर्चाधारी का नाम है। कामत लैंड सेटल्ड होने के बाद इनका जब एक बार बिहार लैंड रिफॉर्म्स एक्ट आ गया तो इनका राइट्स एबॉलिश हो गया। ये कहाँ से इसमें क्लेम करेगा? जो आदमी का पर्चा है भी गजेटेड सेटलमेंट के टाइम का पर्चा है, और फोरपोस्टदार भी अगर था उसका, तो
फोरपोस्टदारी पे थे ये लोग, रेवती कुमारी
ये थे।
हाँ।
और इन्होंने रिकवरी ऑफ पोजीशन के लिए भी गए थे, चूंकि हमारा 150 पैडी इनको मिलना था, ये कहते थे। और इसमें इनका भी शेयर है, मेरा भी शेयर है, और सबका हम लोग का 2/3 शेयर के लिए हम लोग आए। तो ये एक प्योर क्वेश्चन ऑफ लॉ पर ही इसमें 2-3 पॉइंट हमने जो फ्रेम किया है देखा जाए। अच्छा, इन्होंने कह दिया कि सेक्शन 6 का एप्लीकेशन ही नहीं होगा, बिहार लैंड रिफॉर्म्स एक्ट का इसमें एप्लीकेशन नहीं, मान ही नहीं रहे हैं। दैट इज इंटरली परवर्स फाइंडिंग, वो पर भी हमने फ्रेम किया। अच्छा, उसके बाद 1980 में असेसमेंट करा लिए। जब इनका राइट ही नहीं रहा तो ये असेसमेंट से थोड़ी राइट हो जाएगा।
देखिए ये जो फोरपोस्टदार वाला जो भी है
जी,
जो इनको मिलना था
जी,
ना, इस राधिका
और रेवती
कुमारी,
लेकिन पर्चा में तो उन्हीं का नाम है,
पर्चा में भी
उनका
उनका
नाम
नाम
एग्जिबिट 2 में उन्हीं का नाम है।
और डिसेंडेंट्स दे आर द
Legal
प्लेंटिफ्स आर द लीगल हियर्स ऑफ दिस रेवती कुमारी एंड
हाँ,
राधिका प्रसाद। तो इनके फेवर में तो डिग्री हो गया था।
नहीं, डिग्री इनके फेवर में,
The word Radhika Prasad jointly brought a title suit 108
हाँ, वो
of
डिग्री हो
1960।
गया, लेकिन अपील जो है पटना हाई कोर्ट ने उसे
ठीक है, ये डिग्री हो गया।
हाँ।
अपील में वो रिवर्स हो गया
रिवर्स हो गया।
और वो जजमेंट सुप्रीम कोर्ट से कंफर्म हो गया।
लेकिन वो नहीं, वो मैटर सुप्रीम कोर्ट नहीं गया, सुप्रीम कोर्ट का लीगल इयर्स पर गया था।
अच्छा, एनीवेज डिग्री तो सेट असाइड हो गया ना?
डिग्री सेट असाइड हो गया, लेकिन डिग्री सेट
तो ये
असाइड
जो राधिका प्रसाद और रेवती कुमारी का जो इन्होंने जो डिग्री मतलब सूट फाइल किया था फॉर द रिकवरी ऑफ फॉर खास पोजेशन ऑफ जमाबंदी लैंड ऑन अकाउंट ऑफ डिफॉल्ट इन नॉन पेमेंट ऑफ मेंटेनेंस,
जो कि 150 पैडी देना।
हाँ, 150 पैडी देना था, तो वो that suit was
इनिशियली डिग्री, बाद में उसको,
इसका मतलब they were not held entitled to that property.
But the question is that what I want to say, जब एक बार जो पर्चाधारी है और बिहार लैंड रिफॉर्म्स एक्ट का जब एप्लीकेशन होगा, तो the पर्चाधारी will be the rayat, not the घटवा.
What was your status? Your status was, as per your case only, your status was that you were entitled to a share in the maintenance,
But
a share in the paddy by way of maintenance.
Yes.
You do not become the rayat.
नहीं,
Do you acquire the status of rayat?
by virtue of Bihar Land Reforms Act,
Yes.
it will not vest with the government.
No.
हाँ, देखा।
What do you mean? ये जब कब इनका डेथ हुआ? मेंटेनेंस इनका था, इनका डेथ कब हुआ?
ये तो डिग्री के दौरान हुआ।
डिग्री के दौरान ही डेथ हो गया।
66 का डिग्री के बाद, सॉरी 66 के डिग्री के बाद।
देखिए 65 में सूट हुआ, उसके बाद इनका हुआ, तो
देखिए,
इनका जो भी राइट था,
हाँ,
whatever be their right of maintenance,
हाँ।
that goes with them, no? कोई inheritable right थोड़ी है maintenance का।
पर्चा is a very important evidence in the संथाल पर। अच्छा, पर्चा में ये बात लिखा हुआ है, पर्चा में लिखा हुआ है कि he was only घटवा, like
नहीं, आप दूसरे का नहीं, आप अपना केस बताइए।
हम अपना ही केस
आप अपना केस ये बताइए that you were your predecessor in interest were entitled for maintenance, right? Do they acquire the status of rayat?
they acquired the status of by
The
fiction of law
कौन सा fiction of law that they acquire the status of rayat?
for section 4।
हाँ, दिखाइए, उनको भी दीजिए। The right to maintenance will have the status of rayat. दिखाइए।
हमारा इसमें कहना है कि घटवाल का जो भी राइट था समाचलन वाला, आफ्टर ऑपरेशन ऑफ लॉ वो एबॉलिश हो गया, और हमारे नाम से अगर लिमिटेड भी था, तो बाय वर्च्यू ऑफ सेक्शन 14 ऑफ हिंदू सक्सेशन एक्ट इट गॉट एब्सोल्यूट। तो
Absolute तो only maintenance ना?
नहीं, मेंटेनेंस तो पहले वाला, लेकिन जब लॉ का ऑपरेशन आया,
So
तो
do you,
इसको
no, law of a person who is entitled for maintenance from a land by virtue of a share in the paddy, right, does the person acquire the status of rayat?
Yes, that's what I am saying.
हम बताइए ना, कहाँ से आप बताएं?
My lord, मैं कहिए कुछ। Prior to 1956, their status was not maintenance, but they were getting that maintenance and whatsoever.
You see that ये हम इस पर नहीं अभी मानने को तैयार हैं unless आप उनको कुछ authority
नहीं, इसमें तो लॉ दिखाएंगे।
दिखाइए, law ही दिखाइए।
लॉ दिखाएंगे।
The person who is claiming maintenance will acquire the status of rayat upon vesting, and therefore that will become an inheritable right. Therefore that will become an inheritable right.
Question
क्योंकि जैसे ही रैयत का स्टेटस होगा, it is an inheritable right.
मैं कहिए the land did not rest with the government, being a common land, and he was a घटवाल, तो घटवाल का राइट तो नहीं होगा, चूंकि बिहार लैंड रिफॉर्म्स एक्ट में सारे जब वेस्ट हो गए गवर्नमेंट, तो जो भी पर्चा होल्डर से उन्हीं का होगा।
With पर्चा
अच्छा में तो
holder-
इनका नाम नहीं है.
नहीं, पर्चा होल्डर किसको? पर्चा होल्डर by your specific cases that you were entitled to maintenance from the land.
My case is that हमको मेंटेनेंस 100-150 पैडी मिलता था, लेकिन हमारा जो है सो राइट जो भी था वो उस वक्त में जो था वो
उसमें-
क्रिस्टलाइज हो गया 1950 के बाद.
Just a moment. Your case was that on account of non-payment of maintenance, you
Right.
were entitled to take possession,
रिकवरी
recovery of possession. तो ये जो condition precedent था on account of non-payment of rent, you were entitled for recovery of possession. तो ये जो सूट आपने फाइल किया वो तो ultimately आपके against में decide हो गया.
हाँ ठीक.
So therefore, by any means, you are not entitled for recovery of possession because there was no default.
But it is
That
a
is-
family property. You should kindly appreciate. It is a family property.
So
I am not an stranger. The defendants are also not an stranger. He is taking advantage only of the fact that it is his name is as a Ghatwal is there. The question is that when the Ghatwal itself get abolished and after the operation of law, so who will be the Rayyat? That what is the question?
So his name was recorded as Rayyat in Ghatwal.
1980 में इन्होंने असेसमेंट कराया, लेकिन जब 1980 में असेसमेंट इनके नाम से नहीं हो सकता है, अगर कोई डॉक्यूमेंट इन्होंने अगर लाया भी है तो उसका कोई वैलिडिटी नहीं है. इन द लाइट ऑफ दी मतलब पारा ई देखा जाए,
सुनेंगे आप,
अब ई देखा जाए,
कल सुनेंगे.
इसको कल देखा
आज नहीं, आज सेकेंड हाफ में नहीं हो पाएगा.
सेकंड हाफ में तो एक मैटर
आज नहीं हो पाएगा सेकेंड हाफ में, इसको कल सुनेंगे. Essay number 196 of 2023. The learned counsel for the appellant has submitted that the plaintiffs are the descendants of Radhika, Prashad and Revti Kumari. Legal heirs. Legal heirs of Radhika, Prashad and Revti Kumari, who were entitled to claim maintenance from Ghatwal. And even if their title suit number 108 of 1965 seeking khas possession of property on account of non-payment of maintenance was ultimately decided against them, they still acquired the status of Ghatwal, status of Rayyat by the operation of law, that is upon coming into force of Bihar Land Reforms Act. Yeah.
as the name of the Revti Kumari and Radhika Prashad was recorded in the Pasha.
As the name of Radhika Prashad and Revti Kumari was recorded in the Parcha issued by the Ghatwal.
Issued in the Gazetteer's settlement.
Okay. Issued in Gangster Survey Settlement. The defendants क्या claim कर रहे थे? Defendant क्या?
Defendant कहते हैं कि हमारा exclusive है, चूँकि हम गठवाल थे.
On the other hand, it was the case of the defendants that the property exclusively belongs to them as they were the Ghatwals. And upon vesting the property, they acquired the status of Rayyat to the exclusion of the legal heirs of Radhika Prashad, to the exclusion of Radhika Prashad and Revti Kumari. The learned counsel has submitted that upon vesting, the right of Radhika Prashad and Revti Kumari to get maintenance does not get extinguished. Right?
No, they become rare. That what is by
Does not get-
fiction of law.
Does not get extinguished, and they acquire the status of Rayyat by virtue of fiction of law. However, he submits that he shall satisfy this court on this point by producing any judgment / referring to the provision of law. Post this case for further hearing tomorrow. 10:30 बजे 2:15. नहीं, कोई दिन तो यहाँ पे भी 10:30 बजे आया करिए.
इसमें नहीं आते तो हम आओगे.
पार्ट थर्ड मैटर को 2:15 में नहीं.
इसको समझो मुझे.
नहीं
इस-
आप आ
इस-
जाइए 10:30
इसमें थोड़ा इसमें हो गया
बनते हैं
I will have to
क्या
get it. Yeah, today actually I was under the impression कि it's 215 वाला केस होगा
होगा ही 215 वाला 215 में होगा
इसमें हम उसी में ज़्यादा रेडी हो रहे थे इसमें नहीं इसको 215 पे रखा
थर्सडे को रख लेते हैं 10:30 आप तैयार हो जाइए जजमेंट मिले तो एडवांस में भेज दीजिए प्रोविजन ऑफ प्रॉपर्टीज
रामानंद प्रसाद देव का जजमेंट हमने रेफर किया दिखाएं
चलो भाई साइटेशन कौन सा बता दीजिए ना बताइए कौन सा जजमेंट देखो
भैया रामानुज प्रसाद देव 1981 सुप्रीम कोर्ट 1397
1981 सुप्रीम कोर्ट
13 right 1397
139
sir right of prima facie पर ये जजमेंट है which is also involved in this मैं clause 10 में भी लिया
The learned counsel has submitted that he would be relying upon the judgment passed by the Honorable Supreme Court reported in 1981 SC 1397.
The reason is that the Ghatwal was in possession in a representative capacity. That is the reason. If you are in possession in a representative capacity, then it cannot be your exclusively yours.
Whose representative?
This Ghatwal.
Ghatwal, what is the status of a Ghatwal? बताइए
Ghatwal का status तो
लीगल स्टेटस में उसको कैसे समझाएंगे
Ghatwal legal status is like जमींदार.
जमींदार ना तो रिप्रेजेंटेटिव कैपेसिटी क्या
फैमिली का रिप्रेजेंटेशन कैपेसिटी क्लास 10 में हमने लिया The learned appellate court while passing into judgment degree to consider that the property was for Pasdar tenure of Lakshmi Lal, second son of Daryal Lal, but failed to appreciate that the law of Pyramid Generature vis-a-vis effect of entry made in Jamabandi number 36A in Radhika Prasad and Rishi Kumar.
कहाँ पे ये क्वेश्चन नंबर
क्लास 10 पढ़ रहा है ग्राउंड लिया
इसका कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ
which depicts that Samachara Lal Ghatwal was in possession of his sole property in representative capacity, and after enactment of Bihar Land Reforms Act, he no more remained as an intermediary, and suit property was deemed to be settled with Radhika Prasad and Ripti Kumari being descendants of Darya Lal, as held by the Honorable Appeals Court in the case of Ramanand Prasad Dev, reported in 1981 Supreme Court 1397. For that, the learned appellate court also failed to consider that Revati Kumari, who was having Pasha, showing her entitlement for 150 mounts of dairy, together with her husband Radhika Prasad, became absolute owner of the fruit property by virtue of Section 14 of the Hindu Succession Act, and plaintiff appellants being her legal heirs, as held by the Honorable Patna High Court by order dated such and such, and also affirmed by the Honorable Apex Court by the Exhibit 6 and 7, passed in first appeal number so and so are entitled to 2/3 property in this one. We are only claiming 2/3, not exclusive. When he is claiming exclusive, it involves my lord substantial question. No, I will satisfy you. इनको चाहिए था फर्स्ट अपील में के खिलाफ सुप्रीम कोर्ट जाते वो नहीं जाकर के इनको सूट फाइल नहीं करना चाहिए तो राइट उनको डिटरमाइन कर ही दिया इनको लीगल मान दिया इशू है इट रिक्वायर्स कंसिडरेशन एडमिशन
अगर मान लीजिए सब्सटेंशियल क्वेश्चन ऑफ लॉ ए को हम देखें
जी
उसमें एक लाइन अगर ऐड कर दें है ना? And the suit property would be deemed to be settled in the name of Radhika Prasad and Devti Kumari, Parcha holders, who were entitled for maintenance. ये तो admitted fact है ना? They were entitled for maintenance.
Yes.
तो यहाँ पर राधिका प्रसाद and Devti Kumari Parcha holders who were by fiction of law who were entitled for maintenance. हो जाएगा उतना में?
हो जाएगा,
ठीक है?
हो जाएगा। और ये भी इम्पोर्टेंट है, बी वाला।
बाकी सब तो देखिए जजमेंट जो है वो तो जजमेंट क्वेश्शन ऑफ लॉ में क्या लिखेंगे?
ये भी इम्पोर्टेंट है क्योंकि इनका राइट खत्म हो गया आफ्टर इवोल्यूशन ऑफ जमींदार। Whether the learned appellate court while passing between judgment and decree committed serious error of law has completely failed to appreciate that rent assessment made in favor of Samachar and Lal, white case number such and such, exhibit D.
ये समझे बस इतना हो। गढ़वाल थे, उनका स्टेटस जो है आफ्टर वेस्टिंग उनका स्टेटस क्या रहा? They were the equivalent to जमींदार्स, गढ़वाल्स। तो आफ्टर वेस्टिंग तो पूरा प्रॉपर्टी वेस्ट कर गया, पूरा प्रॉपर्टी वेस्ट कर गया ना?
जो भी आदमी उसमें उस समय पर्चा होल्डर था उसको तो होगा।
हाँ उसका होगा उतना ही। तो इसीलिए सब्सटेंशियल क्वेश्चन ऑफ लॉ ए शुड बी सफिशिएंट। हाँ
यार दो तो एक्स्ट्रा लिखना पड़ता है जो हमारे समझ से है। एक बार अगर जैसे कोई एक पॉइंट फ्रेम हो गई तो वो सुप्रीम कोर्ट का जजमेंट है कि दूसरा आपको रेंज आप विद ऑफ कोर्ट से कर सकते हैं। बहुत बार एक सफिशिएंट नहीं। सी भी मेरा ठीक है। Whether the learned appellate court while passing between judgment and decree committed serious error of law in recording a finding there is no unity in title information. That suit property is the exclusive property of Samachar Lal, who was Gadwal, and after death of Ritu Kumari, the suit property which was a common man retains its original character. ये चीज़ भी गलत फाइंडिंग।
तो ए बी सी तीनों पे, ए बी सी तीन पर ए बी सी तीन सब्सटेंशियल क्वेश्चन ऑफ लॉ विल बी सफिशिएंट। अब जो है ना इतना सब्सटेंशियल क्वेश्चन ऑफ लॉ को ना फर्स्ट अपील में मत बना दीजिए, बस दैट मच शुड बी सफिशिएंट। यहाँ पे लिखिएगा, considering the submissions, this second appeal will be heard on following substantial question of law A, B and C, ठीक है? और A में एक लाइन हम ऐड किए हैं, by fiction of law who were entitled for maintenance, ठीक है?
सेक्शन 14 का रेगा ऑफ प्रीवियस सक्सेशन ऐड कर दे सकते हैं।
We'll see that.
वो भी हमने लिया।
We will see that maintenance का क्या right होगा वो सारा उसी में ही है।
Absolute right इसका होगा।
Issue notice to the किसको notice respondents कौन है?
1 to 11.
Issue notice to the respondents for which requisite under ordinary process be filed by the appellant within a period of 10 days. Let the records be called for from the concerned court post this case on 8th of April.